All right, wonderful. Joint Judiciary Committee, welcome back from our brief lunch escape and eat in. We are doing the people's work today, as glorious as that may be. Again, we are 10 minutes late coming back. As you know, these short little breaks never turn out to be as short as we anticipate. So those of you watching in the public, we have completed the substance of our work on the agenda for the last 2 days, except for Title 25, which that work is going to continue into the afternoon. But right now we are on the time frame for our agenda of hearing public comment. So this is general public comment that we're going to hear from anyone who may want to provide that. And I think we do have some folks both online and here with us today in person who'd like to provide that public comment. So if you could go ahead and come forward. And for members of the public who might be watching live and here, we are eating our lunch live as we are working in order to be judicious with our time. So forgive us as we are munching on our lunch and taking in testimony, recognizing the unique situation we are in for time. Welcome. If you would introduce yourself to the committee.
There we go, green light. My name is Dan Aramosby. I'm the Sweetwater County Attorney. I'm serving my second term. I'm also on the board of directors for the National District Attorneys Association representing the state of Wyoming. If I would have known you guys were doing lunch, I would have brought my Halloween candy that I left out in the car and just shared it with you. But I appreciate that you work through your lunch to hear these public comments. And I'm here today to speak regarding the county attorney salary cap. Right now, the problem is that we have is maintaining staff. That's part of the problem. When I came in 2015, I recognized that this was going to be an issue, that we were going to lose people to the private sector. But the issue, that's always been the issue, actually. When I left college and law school, I got a job at the county attorney's office, and I left after 2 years to go to the private sector. After 16 years, I figured I needed to work my way back into heaven, so I ran for county attorney. And in doing so this second time around, I realized that not that many people are applying for these jobs. Matter of fact, very few are applying for these jobs. Sure, they're going to come into a county attorney's office. They're going to be trained. They're going to get the training, the experience, all on the taxpayer dime. Then they go out into the greener pastures of private practice. The problem is that nobody is filling the void that they leave. And that has been a problem. If we look at even public defender contracts, a young attorney can get a public defender contract, which allows them to take private cases as well. And that contract in itself pays as much, if not more, than some full-time prosecutors, deputy prosecutors. And so there's really no incentive to come in to be a prosecutor at the rate that it's going. If we were to even look at Park County has an opening, and in Park County, they start off at $75,000 with benefits. That's been open for months, and they only have one applicant. So it's not even a matter of quality of applicants coming in, it's quantity as well. So the simple solution to that would be to basically pay those deputies more money. Since they're not under a cap, a statutory cap, then the county can pay them more money. And some counties do that. Teton County, Campbell County, I think Weston does, and I'll probably miss a few. Sheridan, Sweetwater County. My chief deputy makes more than I do. And in fact, in Sweetwater County, I'm asking the county to do a wage study, not for my position, but for my deputy's position, so I don't lose anymore, so that they can be paid a marketable rate that is being paid outside the state of Wyoming. If that occurs, my deputies will be making some as much as I, and a few of them will be making substantially more. And that brings up the crust of this problem, is there's no incentive for those deputies to want this job, to want to be me, to want to be the county attorney. If something were to happen to me in this term, is my chief deputy going to want to take a cut in pay, to take on added responsibility, added decisions, added scrutiny? No, absolutely not. And that's the main problem, is that the elected officials are capped at $100,000. And that $100,000 is not what it was back in 2015. We don't receive a cost of living raise or adjustment like our staff does. The county attorneys are tied at 100 and 100 total. And with the cost of living rising and inflation rising at a greater speed than we've seen in 30 years, it's only going to get worse. So why is this a problem? In my opinion, it's a problem because I don't think the community, I think the position of county attorney has a greater day-to-day impact on the community than most elected officials. Every case, every criminal charge, every arrest goes through our office. We're charged with evaluating, we're charged with implementing the law, interpreting the law. We are the first judges on the scene. We have to, at the time, decide, are we going to charge or are we not going to charge? And sometimes not charging is the toughest decision of all. Then we also have to worry about and walk the victim and the victim's family through the process. And at the same time, we're dealing with law enforcement with 4 agencies just alone in my county. I have to deal with 4 different agencies. And the adverse reactions from the defendant and his family and friends. Then we have trials, and we have to decide whether we're going for incarceration or community supervision. These are decisions that are made at our level. And then when we have to go to trial, it takes a tremendous amount of time and preparation, and it takes a tremendous amount of skill to present a proper and legal trial. It's not getting any easier. County attorneys also have the civil responsibility of representing the county, the people's government, the county government, all the department heads, the sheriff, the detention center. We are charged with having to provide counsel on personnel affairs, on MOUs between agencies, liability of contracts that come in, road and bridge, all of that. And that too is not getting any easier. Everything that this committee does and has done the last 2 days, those are things that we're going to be dealing with, that my office will be dealing with. We were talking about Title 25 earlier. That's something we do on a daily basis. Sexual registration, that's something we do on a daily basis. Everything that comes out of this committee is something that we have to implement, and we have to provide proper and qualified treatment of each and every one of those aspects of the law. The scope of importance of what we do as county attorney is large. And right now, with the current cap at 100,000, we're just not getting the incentive out there for people to want this job. It's not about me. It's not about any individual county attorney in this state. It's about the position itself. And we need to have incentive to draw candidates in. And that incentive is twofold, because once you get in, you need to have that incentive to maintain the quality of that office. I could sit here and I honestly tell you that I don't see, if it's to remain the same, the cap, I could honestly see holding my position in perpetuity. I don't see anyone wanting this job in Sweetwater County. And what does that do for the person at the head? Intrinsically, I'm going to do my job, but there's no external incentive to provide quality leadership at that role. So what are we asking for? We're asking that the statute that sets the salaries be amended so that it reflects the guidelines that have been recommended by the National District Attorneys Association, the American Bar Association, and the National Advisory Commission on Criminal Justice. The standards by the National Advisory Commission on Criminal Justice states that the district attorney should be compensated at the same level as the felony judge of their district. And in Wyoming, that's the district court judge. That is the recommended standard. That's not something we pulled out of the ether and we're presenting to you. It is a recommended standard by the people that in the know, so to speak. I provided a PowerPoint. I don't know if everybody got it. I tried to send it to Mr. Fuller, but it kept on being returned. But it was a PowerPoint that I presented last year when we addressed the Joint Judiciary Committee, and it establishes and does a walkthrough. It even has a proposed amended statute. And what the statute would basically do is the county attorneys are tied to the district attorney's salary. The district attorney salary under statute is at $100,000 cap. What we are asking is that the cap, that the district attorney's salary be tied to the district court judges. And what that would do is raise the capacity for the county commissioners, for the local county commissioners to make the move within the $35,000 minimum and the $160,000 maximum. We are not well, we're not asking for money from the state at this point. We're asking for authority. We're asking for the local county commissioners to be granted the authority to go beyond the cap as it is right now, to raise the cap to a capacity. No problem. Okay, thank you. We're not asking, as I said, we're asking for just the authority to raise the cap. And if we raise that cap, then that allows for individual counties and county commissioners to decide what they feel is necessary to bring qualified candidates into the position. I know I sound like Chicken Little with the doom and gloom of this, but when it gets down to it, a poorly managed case, a poorly managed mandate, a poorly managed law, a poorly managed lawsuit has irreparable damage to the people involved. And when it's done on a county attorney level, it has irreparable damage to the community in which we serve in. And so I would ask for your support. And I'd even go a little bit further. I'd ask for you to champion this. We do have a sponsor for a bill, but I think we need as much help as we could possibly get to get this through. That would not within this committee, but we need as much, because if it doesn't happen this year, we do not see this happening until 2026, because we can't change in the middle of a term. And another 5 years of this is going to be very detrimental. And I know there are some that are online, and I'm willing to stand for any questions as well.
Thank you, Mr. Mosby. Any questions? Representative Swanitzer, and if we could allow if there's any other county attorneys on Zoom, if we can bring them forward and have them start their cameras. Representative Swanitzer.
Thanks, Madam Chairman. Just making sure I understood testimony. The national associations think that a district attorney should be paid the same as a district judge. But is that also your testimony that a county attorney should be paid the same as the district judge of, is it 150, 165 right now? 160, that all our, the model would say that all of our county attorneys should be paid $160,000 no matter what county they're in?
Madam Chair, Representative Zonitzer, right now there's 2 district attorneys within the state of Wyoming, and they only do criminal law. And the legislature years ago decided that county attorneys were tied in with that. And so that's the nature of that relationship. We're not I guess I'm not saying that every county attorney needs to be paid $160,000 a year. I think that's up for the individual counties to decide that. The difference between Sweetwater County and possibly one of the smaller counties, Weston or something, is probably pretty different, or even Sublette County. But Sublette County has a different type of civil law that they have to practice in the nature. They have issues similar to Teton County. So I think it's up to the individual. It should be up to the individual Board of County Commissioners to determine what the salary should be based on the nature of the job within their county. The 160 is a cap, and that's what we would be just seeking, to have a cap raised to that amount. Thank you.
Thank you. And members of the committee, based on where we at in the timeframe of our interim work, and we are in public comment, the committee is not in a position and won't be, sponsoring a bill associated with this. I think we heard Mr. Amaspe indicate that he does have a sponsor of the bill, but not a member of the Joint Judiciary Committee. Is that correct?
Madam Chairman, that is correct.
Are you prepared to identify who that legislator may be?
We have been told that Mr. Greer would be sponsoring a bill.
Good. All right. With that, we will defer to other county attorneys here ready. It looks like we have Ms. Wiseman. Ms. Wiseman, welcome back to the committee. We'll start with you and then move kind of down the list.
Thank you, Madam Chair, and Co-Chair Olson and members of the Joint Judiciary. I appreciate your time today, and I will not belabor what has been stated by Mr. Aramowski. I did provide you all with correspondence, I believe on Wednesday of this week, which just outlined some of the highlights as I see them with the problem that we're facing and a potential recommendation going forward. And I, as Mr. Aramowski, support the cap being either unlinked from the district attorney, which could be accomplished by amending 18-3-107A Romanet 2 and then adding D. And by adding another subdivision, a subparagraph, you could essentially put into effect a new provision which would allow the county attorneys, county and prosecuting attorneys from January 1, 2023 forward to earn an amount not to exceed that of a district court judge. So I recognize several different ways to potentially modify this to allow for an increase in the cap. That is the idea that I have had, and certainly Mr. Aramosby and we spoke before of this Joint Judiciary Committee last year in hopes to get a bill off the ground. We were unsuccessful, but this is of great importance to me. And I think it really assists not just my office, but all of the offices within the state, and allows the legislature the ability to plan for the future of Wyoming. The fact that this statute has not been amended in over 10 years now is quite significant. And as you have read from my letter, I am probably the county attorney with the most disparate amount of salary between myself making $100,000 and my chief deputy in one of my divisions making almost $148,000. And it is significant. I do love my job. I love the public service that I get to provide, but I do believe that it should come with the appropriate compensation based upon the jurisdictions that each of us practice and serve within. And with that, I'll stand for any questions, and I so appreciate your time. Thank you.
Thank you, Ms. Wiseman. Great to hear from you. Further public comment on Zoom? Mr. Barron?
Yes, thank you. My name is, Madam Chairman, my name is Joe Barron. I'm a county attorney in Crook County. I had sent a comment letter that I see was posted, and the folks there have that. I would like to speak in support of the recommendations there by Ms. Wiseman and Mr. Espen. And what I want to point out is this, is that if you don't get this changed now, we're going to go another 5 years without this getting changed and this cap being continued for upwards of 15 years. And where we're at right now is this: we've already got half a dozen county attorneys at this cap and another half a dozen that are fairly close to this cap, well above $90,000 that are at this cap. For comparison purposes, you need to understand what the competition is here. The Gillette city attorney have been trying to fill that job is between 105 and 135,000. The Cheyenne city attorney is $130,000 to $160,000. The other thing I want to point out is that the Legislative Service Office did a research memo in 2020, May of 2020, and it indicated various salaries on that. And there was an error in that document, which indicated on the last page, I think it's on table 8, that the cap for county and prosecuting attorneys and DAs was 120,000, and that's incorrect. It's never been that. It's 100,000. The other thing I'd like to point out is within that document, it looks at a Colorado study, and in that Colorado study, it indicates one county. This is a 2020 study, Ouray County, which was at $96,000. They've been unable to fill those positions, I believe, because they're always sending me advertisements that ask this, and what they've raised their salary there to is $119,161 to $148,000 is this advertisement that I received earlier this year for that. And also, that's a county of 4,000 people in southwest Colorado. And so the other thing is, since this thing, just point out, since these salary was set 10 years ago, the cost of living has gone up at least 25% during that time. So we're talking about a 25% pay cut And probably over the next 4 years, we're looking at, at least a 3% or more greater inflation rate. So the real earning level of this is going down. Lastly, what I'd like to say is this, I discussed a little bit the historical nature of this. And when I started, as many of you know, I've been doing this for a while. I started out in 1986. Most of the county attorneys back then, offices, were just converting over. They had all been part-time offices. The 1980 legislation had changed that to the 2 DA systems, and that had gone from part-time offices, county and prosecuting offices in Natrona and Laramie counties, and they went to the DA system. And most other counties were part-time, and the laws that were put in place then allowed an increase in wages to create a full-time, more professional prosecutors, both for electeds and for the deputies, attorneys in that. The other thing that it does is it avoids the local conflicts of interest between part-time offices and your private clients. And what's going to happen, and this is my prediction, it's my opinion, it's my prediction, and it's already occurring, is what we're going to see is with these caps in place where they're at, because you can't get qualified folks to run for these jobs, they're going to turn these jobs back into part-time jobs. And when they get part-time jobs, then you're going to go back to the conflict. And we've had this around the state. And what we've seen around the state is this, is that, people don't really care much about the county attorney's offices until they have one that they can't deal with or that is incompetent in their job. We've seen this in several counties around the state. And by the time that person gets elected, it's just too late. And so that's a prognosis, but the realistic thing is the Constitution says that it's in proportion to the value of services rendered and the duties performed. And I do believe that if you grant this, you should give the local board of county commissioners a local control to proceed and let them make the decision on, because most of the money's paid by them anyway. I'll stand for any questions.
Thank you, Mr. Barron. Questions for Mr. Barron? Co-Chairman Olson.
Thank you, Mr. Barron. You just said something I think might be helpful for the rest of the committee to know, just as they're working this and considering this issue throughout the session, and that's the funding portion of it. And I was thinking about it when Representative Zwanser was talking about district attorneys, and district attorneys are in the Natrona and Laramie County are funded 100% off of general fund. Their salaries are. The prosecuting attorneys, as you just mentioned, is likely in most counties is going to be majority funded by counties, because the state only reimburses 50% of the salary up to a cap, I think, of $30,000. Is that accurate, or can you describe it accurately on that funding model?
Mr. Fuller, do you know?
Yeah, Madam Chairman, Chairman Olson, under current law, the state pays 50% of the salary of the county and prosecuting attorney, and then 30,000 or 50% of each assistant to the county and prosecuting attorney.
Okay, so the cap of 30 only applies to the assistant.
Mr. Barron?
Yeah, Madam Chairman, Co-Chairman Olson. The other thing about that is that's funded through budget item 160. And essentially, in my review of this, that funds about 35% of a local county and prosecuting attorney's office, because the county pays all the benefits, all the other salaries, all the other expenses of that. The other thing about that is that, and so the point is that the local boards of county commissioners have a greater stake in that than anybody, because they're paying more of the bill to do that, but they're also impacted the most too. And so the second thing about that is is that in that legislation, I think it's 183107F, that the legislature, it has the legislature, let's say, is protected in that this is subject to government appropriation. So if the legislature only funds X number of dollars into that budget item, then it's if the budgeted amount is unable to fill everything as Mr. Fuller said, then it will be prorated out between the counties, any cut, let's say, or unfilled amount in there. And if there's legislation that was cured in 2013, I believe by Senator Perkins, it was capped by the appropriation amount.
Thank you, Mr. Barron. With that, we'll go to Mr. Crisson.
Thank you, Madam Chair and members of the committee. I appreciate you giving us a few minutes today. So I'm Mike Crossan. I'm the Sublette County Attorney, and I just kind of want to bring a real world experience to you. And I'll be very brief because I have court at 1:30, and I know you have a lot more to do today. So I've had a position open in my office for 3 months, and it's been advertised on the bar website. And I wasn't getting any responses at all. And the cap that I'd listed was 87,000, which is what our commissioners had authorized as the maximum salary for a deputy to fill that position. So after it went through a cycle at the bar, I had to re-up pay again to keep the ad going with the bar. No responses at all. Went before my board of commissioners and asked them to raise the cap to 94,000. And they graciously agreed to do that. And I finally, as of this week, and that was about 3 weeks or a month ago, and still nothing for, between that period of time and now. And as of last week, I had 2 applicants that were going to interview, but frankly, we're at that point where the salaries just are not sufficient to attract many applicants or qualified applicants, and hopefully we will get a qualified applicant. The other dilemma we face, in counties to a higher degree, I think in Sublette and Teton, even worse than Sublette, is our cost of living. So if I can get somebody interested in the job, they have to find a place to live here. And I'm sure you're all aware of the housing situation in our part of the state. There's people from out of state on a waiting list taking residences sight unseen from realtors. And so there's nothing on the market. It's hard to find a decent rental. So I think we're going to have much more compensation to lure those good applicants to come, not only take jobs throughout the state, but particularly in places like Sublette County and Teton County. And as other county attorneys have stated, it just doesn't work long-term to have deputies making more than the county attorney. It does disincentivize those deputies from wanting to step up. Often that chief deputy is going to be your most qualified person to step into the role of county attorney, assuming other local attorneys in the bar don't want to run for the office. And again, why would they when they're making substantially more than the county attorney? It's going to be my intent this July during budgeting to ask that the commissioners increase the salary of my chief deputy to be substantially more than mine, because he's really good. I want to keep him. And I think, the salary has to be commensurate with the skill and services they provide to the county to keep them. And so with that, I likewise would be happy to answer any questions. I do think it's essential that the cap be raised, and respectfully ask that you do that if at all possible. Thank you.
Mr. Crisson, thank you. Any questions for any of these county attorneys? All right, seeing none, Mr. Crisson, Mr. Weissman, Mr. Barron, and Mr. Aramaspe, the Joint Judiciary Committee thanks you for your public service. No, many times it's a thankless job, but we do thank you today and always, and appreciate you being here and providing such thorough and thoughtful testimony to us for us to consider. We look forward to seeing that bill by the sponsor here in the 2022 session and being able to provide thoughtful comments to it.
Thank you, Madam
Right.
Chairman.
Thank you.
Thank you.
Mr. Fuller?
Yeah, Madam Chairman, we do have one other person, I think, who would like to comment on this topic.
Okay, great.
It's Representative Stith.
Oh, Representative Stith. Representative Stith, welcome back to the committee. I don't see you yet on screen. Committee members, I think Representative Stith did send us an email here recently, looking at some maybe other states and their salary compensation. Representative Stith, your thoughts? I know both you and Washit were no votes on this conversation in previous years in front of this committee. So what are your thoughts today?
Madam Chairman, no, thank you. I won't take too much time. After voting no a year ago, when the state's budget picture was bleak, I sent out about 8 or 10 requests for public information to different counties in Utah and Colorado, asking what their salaries were for their prosecuting attorneys. And so the result of that is summarized on a short spreadsheet that I emailed to you around noon today. And essentially in Colorado, the minimum is $130,000 for the county attorney or district attorney, as they're called. And then in Utah, Tooele County, which has about 69,000 people, the salary there is $127,000. And then also in other counties in Utah, it seems that they're paid substantially more than the $100,000 cap that we have in Wyoming. So upon reflection, to me, it seems that there's probably some upward adjustment of the cap that is warranted. And thank you.
Very wise, Representative Stith, very wise. All right, thank you. Any comments, committee? Representative Stith, thanks for your work on getting us that additional information. Those county comparisons that are similarly in size to many of ours in Wyoming, I think is quite helpful and useful, and appreciate you coming before the committee and sharing with us kind of your change in position and the reasons why. So thank you so much. Any additional public comment on this topic, Mr. Fuller? There's one more in Zoom. Oh, Senator Kolb. Senator Kolb. Yes.
I should have, thank you, Madam Co-Chair. Yeah, I guess my past history with understanding the situation is pretty in depth. Sweetwater County, we raised the cap to 100 a while ago. The issues come up that we can't retain folks in the office, and certainly quality folks at that. As it pertains to 183107F, I think that's an appropriation that can be adjusted. And if the Board of County Commissioners in said counties think that they need to pay more for their county attorney, I think they should be able to do that. I think it should allow them the latitude to make those decisions because it's based on their budget and what they perceive their need is as elected officials closest to the people. So I wanted to add that to this conversation. Thank you for my chance to comment, Madam Co-Chair.
Thank you, Senator Kolb. I share those sentiments. Representative Yen?
Thank you, Madam Chair. So I'm curious, and this will probably be more important when it comes to session, but what was the point of having a cap in the first place? And why wouldn't we just let the counties deal with it in the proper way? And I know we have certain set amounts for specific elected officers generally, but I'm curious of what the public good is of having the cap in the first place. Thank you, Madam Chair.
Representative Zwanitzer?
Thank you, Madam Chairman. It goes back to the founding of our state and our constitution. Admittedly, it was copied from 2 other states on the fact that the legislature sets the office salaries for every county officer. Certainly, we had this battle 10 years ago. I still believe it was an abdication of our authority to allow counties to have ranges. Other states do it differently, where they actually have, legislative level panels, I guess we could call them, where they set salaries. I don't know in my world why we wouldn't do either a constitutional amendment if we really believe that counties should have that power, their county commissioners, to set those county officers, or we do a housing allowance. Then when I read the Constitution, it continues to say, as we mentioned, the level of services provided. So the level of service should be the same, right? Everybody should be getting the same amount of representation, intelligent county attorney, no matter where they live in Wyoming. I would argue, no matter if they're in Niobrara, Weston, Teton. So I have significant difficulties, as you can all tell, with allowing counties to set salaries based on housing prices. I think housing allowance or other I don't know, supplemental benefits is a much better way to go. But the reason, to answer Representative Young's question, is the Constitution says that the legislature sets county officer salaries.
Representative Washit.
Thank you, Madam Chair. Since my name was raised, I thought I might comment. I don't think our memories are so short that we don't remember where we were at the time that Representative Stith and I cast our no votes. The economy was in a very scary and precarious position at the time we cast those votes. But I would also add that I believe if we were to ask some of the department chairs who have been before us in the last few days, whether they think their employees in the various agencies of state government also need salary adjustments, whether they are having challenges recruiting and retaining top-notch talented people throughout state government, I'm sure we'd hear something similar to what we heard today from the prosecuting attorneys. And so I'm not opposed to the idea of allowing county commissioners some discretion in this matter, but I thought that at the time we were asked to make that vote last year, I guess it was, the optics were really horrible in my estimation, that to be voting for that at a time where we were talking about, you know, layoffs and all sorts of other possibilities throughout government. I thought that would be a horrible time to make such a vote. So I look forward to Representative McGruer's bill, and we'll give it due consideration when it comes before us.
All right, additional comments from the committee? You know, one mention Representative Zwanitzer indicated, and I know we previously heard kind of a similar, I think, concern from Representative Stith in the past. This committee has taken up this issue before about the Constitution. So as you continue to have these conversations and depending how this next session turns out, you know, the legislature is not afraid to do constitutional amendments as big of a hurdle as they may be. And so something for all of the stakeholders to consider for whether or not it's time for the people to decide whether or not it's appropriate for county employees to have their salary set by county elected officials, like county commissioners, as opposed to the state. So conversations, I think, that deserve continued conversation and different options there on the table. With that, any further public comment on county attorney salaries or public employee salaries? Sure.
Yeah,
The
Madam
public
Chairman.
comment is open on anything.
Oh.
So you can, the public is free to comment however you wish, but of course, time is ticking.
I just say it's been 20 years since legislators got a pay raise. And it does worry me, the state attorney general. I mean, no discussion of raising her wage or the state office. I think last I looked, we have 19 county officials making more than our state treasurer, state auditor, state superintendent, public instruction. And so maybe a larger bill is warranted before the next election cycle, or we're in a 4-year window to look at, you know, things across the board and maybe raise salaries so they're in line with the state level versus county level. Because it does concern me when we have county officers, county treasurers making more than the state treasurer, who oversees 36 billion. That continues to trouble me.
I think that's a fair concern, Representative Zwanitzer. So we have 5 statewide electeds that make $96,000, $91,900. So that's the governor, that's the state treasurer, that's the state auditor, the superintendent. Oh, the governor makes 105. So you know, it is a healthy conversation to have, and it might be an appropriate time to bring that up. I'm sure the county attorneys are panicked by that and cause further mischief to their hopes and bills of keeping it simple and local control. But I do think an appropriate conversation at the same time. All right, with that, committee, any further discussion? Any further public comment generally? All right, with that, public comment is closed for the Joint Judiciary Committee. On any other topics, county attorneys, again, thank you for being here. Committee, now we're going to go back to our work with Title 25. We will not take any more short breaks or anything as the work continues, so feel free, obviously, to just step out as normal and as needed. It looks like we did receive communications from Mr. Beaver over the lunch hour as well concerning the county attorney's comments to the staff comments to 22 LSO 112 Working Draft 5, which is emergency detentions and hospitalization amendments. Committee members, can I just get a nods of the heads? Have you seen that email? Do you have that readily available? We already moved the bill, right? Did we already move this bill? We did not move the bill yesterday. All right. And you were talking yesterday. Okay, so the bill is currently in front of us, committee. Obviously, we moved it over to today, I believe with the intention of likely to work the bill, which was our conversation about how to navigate the 50+ staff comments and the voluminous bill that we have in front of us. Is there a motion on the bill? Co-Chairman Olson has moved the bill. Is there a second? Seconded by Senator Cooper. All right. Committee members, give you a chance to find that email from Mr. Beaver. I'm going to do the same.
And Madam Co-Chairman, simultaneously, you should all have an email in your box from the Department of Health on comments as well.
Who is that email from?
Stephen Johansson.
Okay.
And then I forwarded it, so you might just search my name.
So committee members, how I propose that we work this bill is really just page by page. And I think we're going to see some progress that way. I know it seems overwhelming, but I think we can get there. So let's go ahead and start on page 2. So let's look at the staff comment, particularly on, and I'm looking at this with the county attorneys. Is Mr. Beaver here? Yeah, if we can bring him in, or any other county attorney associated with Title 25. Mr. Beaver, thanks for your comments. I hope court went well this morning.
It did, thank you.
Good. Do you have time with us this afternoon, or are you going back into court or anything else?
I am yours.
Wonderful. And you were not charging by the hour because you were a county attorney.
Right.
All right. So it looks like when we have your comments pulled up on page 2, when we look at the staff comment in page 2, looks like the county attorneys oppose combining provisions from Articles 5, 6, and 7 into a single article, general provisions. You detest the opaqueness of, quote, general provisions in no uncertain terms, when the statutes can be presented in a clearer fashion. So you reject that staff comment as found on lines really 21 and 22 found on page 2. Is that fair?
Right.
Any comments on that particular piece, committee members? All right, seeing none. So here's the piece 2 moving down on lines 28 through 33 of the staff comment. It looks like they concur with the change of titling Chapter 10 to persons with serious mental illness. So committee members, if you agree with the staff comment and you agree with the county attorney's recommendation to adopt that staff comment, I will need a motion to make that happen. Mr. Fuller? Thank gosh for that mask.
Yeah, Madam Chairman, for the first paragraph of that staff comment, I think what the county attorneys are looking to is to go back to their draft, which created, I think, 5 or 6 separate articles that delineated these sections in the bill where there were, say, only 1 or 2 sections in a particular article. So that would be, I think, the question for the committee for that first part. Then the second one would be, I think, a simple, just a title change to the chapter, which we would make just in our normal convention.
I agree. I think for purposes of this, excuse me, let's star that provision of general provisions to come back to later. And let's work those that are right in front of us that we can make some pretty easy amendments to. So committee, is everybody ready to go? Ready to rock here? All right. So would you like to adopt that staff comment on lines 28 through 33? Page 2, is there a motion? Senator Cooper. Moved by Senator Cooper, seconded by Senator Cost. Discussion on that doesn't seem to be that particularly profound. We're just changing the title. Question being called on the amendment. All those in favor say aye. All those opposed? That motion has passed. Okay, committee, now we're moving on to page 5. This is the staff comment on lines 22 through 23 that the committee may wish to consider whether psychiatrists should be included in the definition of examiner above. The county attorneys do not object to that. And so if the committee agrees, is there a motion to add psychiatrists? Moved by Representative Washut. Is there a second? Seconded by Senator Cost. Discussion. All those in favor, please say aye.
Aye.
Any opposed? All right, we are going to now move to page 7. On lines 15 through 17, the committee may wish to consider moving the co-occurring sentence of the definition of mental illness to a substantive provision in this bill draft. Looks like the county attorneys feel like the comment does not suggest where else the co-occurring sentence should be moved, so we can evaluate whether such a move would improve the bill or not. This was a question I had of LSO at the time, kind of not understanding fully this particular staff comment. You did explain it to me yesterday where I did understand, but I have forgotten that moment of wisdom. If you would please maybe remind us the intention of this staff comment.
Yeah, Madam Chairman. So on page 6, the sentence that begins on line 13, a patient may have a co-occurring disorder of intellectual disability, drug or alcohol addiction, or autism spectrum disorder. That shall not serve as a primary cause of a condition necessitating placement in custody, hospitalization, or outpatient treatment.
Yes.
And the question there is whether that is a substantive provision of law that may not be most appropriate for definitions. In terms of, one spot where that may go, I don't have the exact page and line number, but 2510-601, so it begins on page 32, which concerns process, and I think is a general section that applies to just emergency custody, involuntary hospitalization, and outpatient treatment. Moving that sentence to a new subsection in that section would be one option that the committee may consider.
Thank you, Mr. Fuller. I do recall as well that the testimony from the doctor at the end of the day also identified this as a concern in the definition. And at the time, I made a note for the consideration of the striking of that language on page 6, lines 13. Really that sentence that says a patient may have a co-occurring disorder of intellectual disability, drug and alcohol intoxication or addiction, or autism spectrum disorder. But that disorder shall not serve as the primary cause of a condition necessitating placement in emergency custody. So it really would be striking the line, that sentence, very long sentence, starting on line 13 through 19. That was a question I had for the committee's consideration. Mr. Beaver, your thoughts about striking that co-occurring definition?
Madam Chairman, the attorney's overwhelming concern on the definition is simply that it be clear. It's for the legislature to determine what should or shouldn't be included in that definition. We just want clarity at the end of the day.
So you would not object to the removal of that language?
No, not necessarily.
Okay. All right,
And
Representative,
Madam, yeah,
Mr. Fuller?
my apologies, Madam Chairman. The only thing I would note is and this is certainly, I think, has been discussed, it's a policy question. Current law, the definition of mental illness does include a similar type of language in that definition where it does not include addiction to drugs or alcohol, intoxication, or developmental disabilities, except when one or more of these co-occur as a secondary diagnosis with a mental illness.
I like that better. Could you read that again?
Yeah, Madam Chairman, so this is, I'll just read the entire definition of mental illness. And it's kind of tricky because it's been amended, I believe, in House Bill 38. So there's.
So are
kinda
you
two-
reading the one from House Bill 38?
No, that's the current law.
Okay,
The one from House Bill 38 is mental illness and mentally ill means a physical, emotional, mental, or behavioral disorder which causes a person to be dangerous to himself or others and which requires treatment, but do not include addiction to drugs or alcohol, drug or alcohol intoxication, or developmental disabilities. So it's actually narrower than the current definition because it takes out that co-occurring language and just says developmental disabilities is not a mental illness.
Representative Washit.
Thank you, Madam Chair. I just asked the committee to remember the comments that the doctor from WBI mentioned at the end of his day yesterday, where he's talking about repeated hospitalizations of individuals with substance abuse disorder. And so I'm not sure we want to eliminate that from consideration, that someone who's repeatedly hospitalized has that history for substance abuse disorders might be appropriate for some type of intervention in this bill. I'm not sure that the language here is procedural or substantive in terms of something other than a definition. I don't think it fits in definitions, but I'm not completely comfortable that it's a procedural topic either. My 2 cents.
So this, Representative Washington, those are great comments, and it is what I kind of keyed into yesterday as well. Was reminded that this concept of the connection between an underlying brain disorder and a co-occurring condition, which could be substance abuse, is common, I think, throughout the United States, and certainly has always been the case in Wyoming, that substance abuse by itself is not enough to have you be involuntarily hospitalized, even if that substance abuse by itself is in connection with being a danger to themselves or others, which I found absurd. Just being in the criminal justice system long enough, I'm aware that oftentimes these mental health concerns are present because of the influence of substance abuse. An individual is intoxicated, they get in a fight, they become suicidal or homicidal. But for that level of alcohol intoxication, they may not be dangerous. So, I found that somewhat complex, and I don't know if the practitioners, the medical providers just go ahead and find a diagnosis of a mental disorder in that moment in time. I see you wanting to make a comment. Please come forward very briefly. Yes, Ms. Somerville.
Thank you, Madam Chairman. Andy Somerville with WAMSAC. I just wanted to briefly comment in the consideration of whether to title somebody for a substance use disorder diagnosis only. There are states that do that. Colorado is one. They have essentially what we would call a separate system, separate from the mental health Title 25 system. And then I would also add that approximately 70 to 80% of our clients with substance use disorders already have co-occurring mental health disorders.
Yeah, Ms. Somerville, thank you. Stay close, stay up
Thank
front. So committee, in light of where we are today, in light of what the original purpose as well as of our task here, which was to help streamline the legal process associated with how Title 25s work, it's my suggestion that potentially we take up that issue that the doctor identified, that Ms. Somerville has indicated, that Colorado does, and perhaps look at another option available that will be very expensive, related to just the substance abuse. And I think for purposes of our conversation today, where we are, we don't upset that apple cart and keep this nexus associated with a brain disorder. So where I'm at now on this piece, curious to hear any other committee members' comments, is just to leave that definition as it is. And to disregard that staff comment on lines 14 through 18. Discussion on disregarding the staff comment. Representative Yen.
Madam Chair, I wonder as an alternative, why don't we just take the existing Title 25 definition of mental illness? And what is the benefit of this version of wording where it kind of feels awkward with the second sentence, the definition, than the original definition of mental illness?
Mr. Beaver, I think you indicated, and Mr. Fuller as well, that the version we have in front of us in this bill draft is broader than what's currently in statute. Is that correct, Mr. Fuller?
Madam Chairman, Representative Yen, I think it would be a little tricky to just bring that definition in wholesale to this draft just because of the way the draft is structured with the introduction of that term serious mental illness. Because serious mental illness refers back to mental illness. And so I think it'd be maybe a larger change than simply bringing in, a current definition.
All right, with that, Senator Cost.
Thank you, Madam Chair. I just need, why is autism put in here? I'm struggling with that. That's a mental disorder that can be substantial. Why is it singled out in here as not part of that? I just want to answer that if I could get it.
Mr. Beaver?
Madam Chairman, Senator, as is noted later in my memo, there are certain language that we just put in as a placeholder, knowing that there were stakeholders out there who were concerned about this portion of statute. We don't have a dog in the fight as the attorneys. It's for you to decide as the legislature. But the existing statute is confusing, and it is an issue for many stakeholders. So we wanted to put that in front of you.
Ms. Somerville, do you have comments about autism? The definition?
Madam Chairwoman, committee members, so generally, and I'm not aware of any other states that do title for autism, it's considered a medical disorder. It really has more to do with what treatment is necessary to treat that, and mental health placement is not always the best option for treatment.
Thank you. All right. Senator Cost, would you like to make a motion on that section? Co-Chairman Olson?
I guess I kind of I do want to go back to Brian's analysis about keeping the existing definition and the difficulty of doing that, because, and maybe I misunderstood, but I felt like that was the comments I heard from the district court conference as well. Was I wrote down current law might work better when Judge Lavery was speaking on this issue. So I think this seems like it would be a substantial change, and whether we're best suited to make the policy choice or not, I don't know. But if it is possible to go back to the default language, if we're not ready to make this policy choice, and maybe if you could just enlighten me more on why that's difficult to do.
Mr. Fuller?
Yep. Madam Chairman, Chairman Olson, I think here's what would have to happen to make the change. If you bring in the definition of mental illness, then you also I think you would need to get rid of the definition of serious mental illness. You would need to bring in the current definition of dangerous to self or others. And then that would be and then you would just need to go through the bill and make conforming amendments, I think, to change serious mental illness back to mental illness. I think, that's totally a call for the committee though, but that's what that would look like.
Further comments, Co-Chairman?
Well, I guess I would be curious to know how the committee feels about that.
I might go to Mr. Beaver. Mr. Beaver, do you have some comments?
It's a decision that I think should be influenced by the medical providers that have testified before you. We're fine with whatever you come up with, as long as it's clear what you come up with.
Well, that's not very helpful, Mr. Beaver.
I'm sorry.
Representative Yin.
Thank you, Madam Chair. So I'll note in Department of Health's comments, they also would prefer to do dangerous to self or others. I have concerns about having a definition for quote, serious mental illness, because I think that indicates that other mental illness that aren't serious mental illness isn't serious. But I think that is the definition part, maybe we should keep it back to the existing title.
Representative Washut.
I wrote down yesterday when we were talking about serious mental illness, that one of the objectives had to do with not stigmatizing mental illness generally, and therefore having this separate definition of serious mental illness as something apart from general mental illness. So I think that's worthy of some consideration, but I'm also thinking that we could easily get bogged down on this particular staff comment for an extended period of time. And maybe we could just check mark this one as, let's come back to this and keep moving forward to those staff comments so that we can resolve expeditiously and keep moving, and then maybe come back to some of these so we find more troublesome.
I know there's a strong desire to talk about process, and I think we all would do it differently if we were in that position. I think right now the question that we have would substantially alter the rest of the 50 pages of the bill unless we resolve it now. So the question right now in front of the committee, I think that Co-Chairman Olson presented, is whether or not to revert the bill back to the original language. If the committee chooses to do that, I'm not trying to direct the committee in any particular way. I do think that we need to withhold continual work on this topic until the next interim, because I don't think we'll fully appreciate and understand the changes that we would be making, because we don't have it in front of us to work meaningfully. So those would be my concerns right off the bat. So, but that's not my call, right? I mean, that's up to the committee, but that would be my concern. So further comments on turning the language back to its original version and our ability then to meaningfully work the bill with that type of an amendment.
Madam Co-Chair.
Senator Cole.
Yeah, I'd be in favor of just talking about this and having a vote. If we want to revert back to the old language or not. And you're right, this is a turning point in the discussion, but I think it's worthy of a vote at this point. Thank you.
So what we'll do is we'll turn Co-Chairman Olson's discussion point into a motion. Is that fair, Co-Chairman? And is there a second on that motion, Representative Yen? All right, so further discussion on this effort, and we'll turn it into a formal action here. Representative Craigo.
Madam Chairman, just to clarify, what exactly is the motion?
The motion is to remove the definitions associated in the bill draft with mental illness, serious mental illness, and danger to themselves or others, essentially, and replace it with what is currently in statute. Correct? We don't have in front of us right now, but Mr. Fuller does. Representative Craigo, follow up.
Thank you, Madam Chairman. And if we do that, are we proceeding to work the bill, or are we following your advice
That's up to you.
and coming back a different day?
I don't know that we can come back a different day. So we have asked, we have considered the opportunity to do that. Is something that we will ask if needed. And so we'll get the committee's kind of consensus about that. Even if we did come back another day, I think we're in a tight spot for work to do, but that's my take, and not the committee's well. Representative Craigo.
Sorry, Madam Chairman, I should have been clear. When I said another day, I meant like next year.
Oh. That's if the committee chooses to take it up again as an interim. Again, this has gone on for the Joint Judiciary Committee now. This is year 2. In defense of the Joint Judiciary Committee, we did just receive the substance of this work, a month and a half ago in September, really, I think late September. So we have been somewhat limited, but nonetheless, here we are today. So back on the motion, Co-Chairman Olson, you have additional comments.
Thank you, Madam Co-Chairman. I think this is an important turning point, and it's an important decision for us to make because our committee is expertise really relies around the procedure and the process, which is why we're relying so heavily on our county attorney association, who's ambivalent on this, because as Mr. Beaver said, it's a medical decision. And, the only testimony we've received so far is Ms. Somerville's statement on the question of Senator Cost's question regarding autism spectrum disorder. And I believe the testimony is just that's not in any Title 25 type procedure statute anywhere in the country. So we've already hit a point where now we're realizing, are we the Labor and Health Committee, and do we have the right people at the table to make a medical decision versus a procedural decision? And so that's why I make the motion. And I think how we proceed from here, that'll be up to, I guess, the co-chairman, but just leaving it in here and moving forward that's a big policy decision that I'm just not sure our committees has the expertise to make. So that's why I make the motion.
Yeah, further discussion from me on the topic. I don't believe that the definition is that significantly different than what currently exists. I believe there are differences, but I don't think they're profound, that we are going into the realm of not appropriate for the Joint Judiciary Committee, particularly in light of the expertise that has weighed in on this effort from those county attorneys who practice in this area. I think the identification of autism spectrum disorder is important. It's something that we can amend out, as I think what was suggested, and deal with that issue. But I think what we do know, and probably why the county attorneys put that in there and kind of hearing from them, is that certainly the presence of autism spectrum disorder is a continuing challenge for the country and is not unique to Wyoming. And oftentimes individuals suffering from those effects may find themselves in circumstances that look like an emergency detention or other type of law enforcement engagement. Probably why it ended up there, but doesn't mean we can't delete it out now. Those are my thoughts on those concerns. A no vote on the motion. Further discussion, Representative Washit?
Madam Chair, I guess I don't feel quite as hesitant to move forward without resolving this question. While it is very important, I think if we note that it needs further attention, that maybe as we get into session, one of the other committees that will be looking at the other two bills stemming from Title 25 discussions, Labor Health might have a definition that they're comfortable with, that they want to use, or that we could plug in at some point during the session when either the Senate Judiciary or House Judiciary are continuing discussions with this bill. But there were many of the staff comments that I don't think are dependent upon resolving this issue before we move forward. Things like psychiatric medication versus, psychotropic medication, right? That was a staff comment, something we could easily deal with, whether we wanted to add that language in or not. That doesn't depend upon how we define mental illness or serious mental illness going forward. There's some other issues in the bill that deal with things like voluntary hospitalization versus involuntary. I don't think that's dependent upon the definitions that we use here. So I think there's work we could continue to do today, even if we chose to put the ultimate definitions of mental illness and serious mental illness aside for the time being.
All right, question or discussion on the amendment, whether or not to change the definition. Further discussion on changing the definition. Sensing you're ready for the question, all those in favor of changing the definition as found in this bill draft to current statute, please say aye.
Aye.
All those opposed, say no. That motion has passed. Okay. Let's move forward. Page 7. The bottom, there's another staff comment there. Okay, so committee may wish to consider whether the definition of patient should be limited to persons with serious mental illness, as that term is defined in this bill draft. Conversation about that since we've now just removed that particular definition in this bill draft. What should we do, Representative Craigo?
Thank you, Madam Chairman. So I do think we do. I think that definition should include that disclaimer, so to speak, of a person with a mental illness. So patient means a person with a mental illness who is placed in. And if we're gonna think that, it at least ought to include that. So I'd make that motion.
Mr. Fuller, do you understand the motion? No, neither do I. Representative Craigo.
Sorry, Madam Chairman. So page 7, line 22. Patient means a person with a mental illness who is placed in emergency custody or involuntary hospitalization, or who is subject to directed outpatient treatment, just so it has that disclaimer in there that it is a person with a mental illness.
All right,
Pursuant to your staff comment.
moved by Representative Craigo. I think it was seconded by Washit. Further discussion? All those in favor say aye.
Aye.
Any opposed, say no. All right, that motion has passed. Moving on to page 9, the staff comment there.
Madam Chairman, that one I think has been resolved with the definitional change.
Right, so that staff comment is the definition of serious mental illness. We have removed that. So moving on to page 10. The committee may wish to consider defining or clarifying what is meant by psychiatric medication. Ms. Somerville, would you like to come forward and provide any additional thoughts about the definition of psychiatric medication?
Madam Chairwoman, in surveying some of my clinicians, psychiatric and psychotropic medication are used, those terms are used interchangeably, so they're not necessarily both needed in the bill from our perspective.
Department of Health, do you have any comments that you'd like to provide? If you want to, as we work this bill, kind of go out of the normal form that we typically would do. Because I think we need a lot of subject matter experts that might be in the room to help us work the bill, please just maybe raise your hand in light of who's in the room. I think that's okay. And help us out if you can. But if you don't want to help us out, don't worry, but
Madam Chairman, members of the committee, Stefan Johansson with the Department of Health. I believe we articulated this in our comments. I think, as Ms. Somerville indicated, those terms are relatively well understood and interchangeable in the treatment community. And furthermore, this probably goes between a couple of staff comments. When it comes to the state hospital and Title 25 patients, we believe we have the full ability to prescribe medication, both voluntarily and involuntarily for patients based on the court's involuntary hospitalization order. So I know that was kind of a theme that ran through some of these comments as well.
thank you. All right, committee, any action here? Seeing none. All right, let's turn the page. Staff comment on page 11. The committee may wish to consider placing the second sentence in the definition of voluntary admittee in a substantive provision in this bill draft. What did the county attorney say in their document? And then so none of the stakeholders have any thoughts on that. So committee, this is a matter of drafting construction preference. So further thought on this? Seeing none, we'll turn the page. Page 12. The committee may wish to consider whether a patient's statements may be used as evidence for treatment and restraint as those terms are defined in this bill draft. All right. So the county attorneys say that they do not think it would be appropriate to include treatment and restraint in reference to using the patient statements. On page 12, lines 7 through 9, according to the county attorneys, pertain to the 3 types of orders the court considers at a hearing. The court does not make a factual finding regarding treatment or restraints in these hearings. So the county attorneys don't think that staff comment needs any action. Committee members, do you have discussion on that? Senator Cooper?
Thank you, Madam Chair. I'd move to strike that. Line 7 through 9.
I'm sorry, strike where? Where would you like to take action?
Line 7 through 9.
Page 12, lines 7 through 9, Senator Cooper would like to strike. Is there a second?
Second.
Seconded by Senator Kolb. Discussion, Senator Cooper, thoughts about this?
I think, excuse me, Madam Chair.
Say that again?
I think that the county attorney's statement is pertinent here. I don't think that this statement at that point should be used as evidence, and such I'd like to see it struck.
Representative Craigo?
Thank you, Madam Chairman. So I don't think that's what the county attorneys are saying. What the county attorney's comment says is this act talks about 3 types of hearings, one for emergency custody, one for hospitalization, and one for directed outpatient treatment. And what they're saying is treatment and restraint those are part of those they could be part of those hearings, but they're not actually, there's not a hearing or a process for that. And so I think their comments are well taken. I agree with the county attorneys. I don't think we need to include that language, which would mean you wouldn't want to strike lines 7 through 9 because we can use if they say something to us upon arrest, or oftentimes that's where this happens, or when the law enforcement or the examiner, the treatment coordinator, whatever their name will be, contacts them and they say something, for instance, they're suicidal or whatever. We want to be able to use that as a county attorney. You want to be able to use that statement in court and say, look, they told us they were going to kill themselves. We need to be able to do something about it. And if we strike lines 7 through 9, we won't be able to do that.
Representative Provenza?
Thank you, Madam Chairwoman. I have a few issues with this section, and I think this would add to it. I mean, in the original statutes for 2510-109, I think it's subsection G, patients are given more rights in this instance. So they're told immediately that they have a right to an attorney. I wouldn't know that I have a right to an attorney in a Title 25, that one could be appointed to me. And so a lot of my concerns are that this removes that giving that instruction to people in this instance, and removing this remain silent issue, I think is also just a removal of more patient rights. So that's my concern with this proposed amendment and this section.
Thank you. Representative Rodriguez Williams. You're on mute, Representative.
Sorry.
And thank you, Madam Chairman. I'll be a no vote on this amendment and think leaving lines 7 through 9 are essential, agreeing with Representative Craigo. for similar reasons. I think it's important that we're able to use any harmful words, or utterances that are used by the person that's in custody, in emergency custody, in court.
All right, thank you, Representative. Any further discussion on the amendment?
Madam
Senator,
Chair,
Senator Kolb.
it's just a general question to the more learned attorneys in the room. If that's stricken, does that in itself make it impossible for them to consider those statements? I would have thought you still could have considered those statements if it's silent. You know, if there is nothing written about it, maybe someone could expound on that. Thank you, Madam Chair.
Representative Craigo.
Thank you, Madam Chairman. So what this provision is actually talking about is the written statement of rights that we have to give to the person upon their either arrest or detainment by either a law enforcement or a healthcare professional. So we need to inform them they have the right to remain silent. And so that's what it says, is each patient in this, under this act shall have the right to remain silent. So I think we run into issues, constitutional issues, if we don't inform them of that, and it's not included in the list of rights we give them, because we want to be able to use their statements, but we have to tell them ahead of time, we're going to do that. So that's what it's really about.
Senator Cooper.
Thank you, Madam Chair. I appreciate the discussion, and the purpose of the amendment was exactly that, to bring forward the discussion. So I'd like to withdraw the amendment.
Okay. That amendment is withdrawn. Committee, we will work through the bill.
Second agrees.
The second agrees. Good. Page 13. So the question whether or not whether or not a written copy of the patient's rights should be provided to those placed in involuntary hospitalization. So the county attorneys believe that it's unnecessary because the disposition is never ordered without the patient already having been placed in emergency custody when he or she would have received a copy. And you can see their comments in the motion, in the materials provided. So committee, any actions on this? Representative Washut?
Just some comments. You know, we're talking about someone who has mental illness. And then if you give, we just talked about providing them with notice that they have a right to remain silent. Are we talking about a different process here? 'Cause I think the current practice now is that we do give some type of written statement to people when they're involuntarily detained about what their rights are, because that individual may not be able to comprehend oral messages and so forth. And so by giving them a written copy, they can share that with somebody else who might then assist them or be with them or something. So correct me if I'm wrong, at least, back in my day, which was a while ago, we did give written notice of rights.
Thank you, Representative Washut. When I read the county attorney's comments, I think they agree with you that those written rights are provided to them. I think one of the challenges here when reviewing this is a multi-step process. And so knowing where we are in the process while in the bill draft, I think is challenging for everybody involved. So I think you're right. And I think they do get a written statement of their rights. Representative Craigo, is that true today?
Madam Chairman, thank you. Yes. And so I agree with the county attorney's comment, because what they're saying is you're going to receive the written notice upon being taken into emergency custody, and hospitalization can't happen until after the emergency custody. So if someone's placed in a hospital, involuntary hospitalized, they will have already received that written statement upon being taken into emergency custody, which is the 72-hour hold. That makes sense. So it's kind of a flow chart. So you come in on emergency custody, we hand you your statement of rights as the law enforcement / treatment provider. Here's your statement. And then before you can ever be involuntarily hospitalized, you have another hearing, which we get to later in the bill.
And, also if you look at page 13, lines 12 through 14, that provision. All right, so let's turn the page. Page 14. The committee may miss to specify what is meant by custody. So just a clarifying probably discussion. The county attorneys. Senator Cost?
Madam Chair, I was just going to say that lines 8 through 12 there causes concern. I don't know. I think that cleaning that up or doing something with it would probably be in our best interest. I'm not sure exactly what, but it seems like we're setting up people for some maybe. Now, granted, somebody said that sometimes it's people are putting something up, but I don't know. I don't know. It just seems pretty steep. I could be wrong.
Committee, we did discuss this last night, and this has to do with those criminal provisions that have always been in law with the change found in that definition on line 9 of custody, where historically it was a person who willfully causes the unwarranted involuntary hospitalization of a person is guilty of a felony. The bill draft changes from involuntary hospitalization to custody. So a person who willfully causes the unwarranted custody of a person under this act. And this is at the request of the county attorneys to go with custody. And it is to broaden the scope. Representative Zwanitzer.
If I could even go up to A, so I'm just really concerned, you're going to willfully deny another person a right specified by the act. That means if I don't serve them a written copy up there on the page before, you know, in the heat of everything, and you're involuntarily committing someone against their will, you're transporting them. I just think it's a really weird that we're going to have a criminal penalty. I assume there's already criminal penalties for false accusation that someone is trying to hurt themselves or, you know, lying about someone's mental state if it's provable. But I don't understand why we would have a misdemeanor, first of all, for violation of any of the rights specified. I have those 6 that are included, 7 that are included. Yeah, certainly some of them, but I just want to know what the committee feels about just taking out the criminal provisions all the way through. I'm not sure they're warranted as part of the bill, and they should be covered in other areas of the law would be my hope. I'm not certain of that, but I'd like one of the attorneys to say there's already provisions, and this is kind of a weird area that might catch people.
So we're going to hold a question. There's additional comments. So a question for Mr. Beaver, county attorneys on the line, and Mr. Fuller. Are there other crimes that would capture these concerns? Hold that question. Senator Cole, do you have, your hand was raised momentarily?
That was a momentary mistake.
Given? All right. Answers to that question, anyone? Mr. Fuller, Mr. Beaver? Representative Oakley?
Madam Chair, I agree with the comment. I don't think, my thought is that we don't need criminal provisions embedded in this act, in this statute. And what he's referring to, of course, if you committed some sort of, there's false reporting, there's, you know, different types of, I don't know, like forgery, if there was a written act. So I think, so getting to that, yes, I think there would be other ways if there was a criminal act that happened, we could use other titles, and I don't think it needs to be embedded. And I would like to make a motion.
And your motion would be to remove lines 1 through 12 of page 14?
Yes, Madam Chair.
And that's been seconded by Senator Cost.
Madam Chair.
Representative Provenza?
If I could maybe make a friendly amendment, unless it's completely unnecessary, but removing line 28 on page 13, which is the title of that section.
Sure, conforming, yep. Great catch, Representative Provenza. All right, further discussion on the motion? Representative Yen?
Madam Chair, I'm normally against adding new crimes, but this isn't a new crime. It's something that's already existing in Title 25. We do broaden it a little bit, but I think putting someone involuntarily in custody is a big deal, and one that we should make sure doesn't happen. So I'm probably going to vote against this one. Thank you.
Representative Zwaniter?
Thanks, Madam Chairwoman. Can I ask, could we take them one at a time? So I guess divide the amendment. I mean, A and B are, I guess, different in my mind. One is a misdemeanor for denying a right specified, really above, right? So someone comes and says, your clothing wasn't seasonally appropriate. I mean, I just feel like there's a lot of areas there. People are, right, you wore white after Labor Day or something.
Happening.
And so I just feel like, these are hostile situations for some people and they want back at whoever involved. And I think that's much different than B, when you're really causing the unwarranted custody of someone who goes through a process, could be committed, could be there for 6 months. If two people colluded to imprison someone against their will. So I don't know if everybody else, I really just have problems with A. B, I would hope is covered somewhere else, but I want to make sure of that before I take out B.
So you would like to divide?
I'd like to divide the amendment between A and B. On 2 through 6 would be.
I do. Yeah, and we'll make them conforming. And so page 13, line 28, we'll go with both divisions. So division 1 will be page 13, line 28. And then page 14, line 1 through 7 is division 1. Division 2 is page 13, line 28, lines 8 through 12. And so Representative Swanitzer, your motion is to do what with division 1? Strike 1 through 7?
Yes, so I'm in favor of division 1 of removing the misdemeanor penalties for violation of something in the Patient's Rights Act previously.
And that is to repeal, not strike it from this bill draft because it currently exists.
Repeal it
to
in
repeal
law.
it in law.
Correct.
Okay, is there a second? Seconded by Oakley. Representative Washut.
Just comment, even without criminal penalties, I'm fairly certain that there'd be a civil cause of action if someone were to willfully violate the rights elsewhere in the act. And so even though we take away the criminal provision, that doesn't mean that we're giving license to someone to do these things.
Further discussion on division 1? Sensing you're ready for the question, all those in favor of repealing the misdemeanor provision as found on page 14, line 1 through 7, please say aye.
Aye.
All those opposed? That motion has passed. Back to division 2. Representative Oakley.
Thank you, Madam Chair. I mentioned, off the top of my head, a couple possibilities for other criminal penalties or sanctions involved with this. Another one could be false imprisonment. The person is guilty of false imprisonment if he knowingly and unlawfully restrains another so as to interfere substantially with his liberty. Again, just a thought. I do think probably there are, I can't do all the analyzing, plus it would be fact specific, but generally I think that there are crimes in place that would cover.
Mr. Beaver, comments?
Yeah, I'm sure there are other places in statute that could backfill this, so to speak.
Well, just to be consistent with all of your expectations, I disagree. The lawyers are in dispute. I think that this, I don't know that it's necessary. And I think that the statute currently as written for this felony provision is poorly written. It needs work. But I do think it's a bit of a struggle to see what other crimes would apply to this type of factual scenario. There are some that come close. I do think false reporting and false imprisonment are some of those, but I do think this is a unique situation. And I don't like the language as currently written. I don't know what unwarranted means, and I could see that very quickly going to the Supreme Court on that term. But on Division 2, for whether or not to what would be strike this from the bill draft, which means this felony provision still stays on the books. So this felony provision remains as originally written, which says a person who willfully causes the unwarranted involuntary hospitalization of a person under this act is guilty of a felony. I'm guessing the reason why many of our practitioners have not seen it is because it takes a lot to be involuntarily hospitalized as opposed to just emergency detained. And so there's enough gatekeepers along the way that it probably prevents that from taking place. Mr. Fuller, did I say that incorrectly?
Yeah, Madam Chairman, just to be clear, kind of where things are at. The entirety in this bill draft, as it's written right now, the entirety of the current law on Title 25 is repealed.
Yeah.
So this would be a decision to include this in the new language or not.
I see. So currently this felony provision is in Title 25 now, Mr. Fuller?
Madam Chairman, it's 2510 126A.
Absurd. It needs to be in Title 6. Yeah.
Madam Chairman,
Representative
I just
Zwaniter?
want to make sure, if anyone in the room, have we ever used this in the last 5 years? And I'm just kind of looking and no one's shaking their head yes, they know of any time we have.
They wouldn't know.
I feel like we would know. I just want to make sure
The
before.
county attorneys would know because they would be the ones prosecuting the
So-
case. Joe Barron has said never. Never. So do you want to, so the motion is to,
Read it. Current law.
current law. Okay. We have a motion and a second. Any further discussion? I'm not sharing that with anyone. Mr. Fever. All right. Question having been called, please say aye.
Aye.
All those opposed?
Opposed?
No.
No.
Stop. All right, that motion has passed. All right, that provision is gone. All right, turning the page. Page 16. The committee may wish to consider whether the reference in subparagraph F above should be limited to courts, as that term is defined in this bill draft. So we got to turn the page before, I think. Mr. Fuller, can you help understand the staff comment a little bit more directly?
Yeah,
I don't think it's
Madam
okay.
Chairman, so the term court back on page 4 is defined in the draft. Court means a district court where a patient is placed in emergency custody or to which the patient's case is transferred for further proceedings. The staff comment there really, and I think it's a decision for the committee. That is the only reference to district court commissioner in the entire bill now. Current statute expressly authorize, at least for purposes of hospitalization proceedings, a court can appoint a special commissioner. And that's 2510-110K, I believe. Does it do any harm to have it in there, Madam Chair and members of the committee? Probably not. But that was just to highlight that. Really, the highlight is this is the only time it's referenced in the bill.
Sure. Okay, thank you, Mr. Fuller. Discussion on the staff comment? I think the staff comment is sound in that there is prudence in, I believe, for the purpose of the staff comment is to amend on page 15, lines 20, to just say courts, because that's consistent with the definition as found in the act. In courts, what is included in courts is commissioners. That's all part of the court. Because that's how commissioners are created. Is that correct, Mr. Fuller?
Well, if that's the intent, then if you want to include commissioners, then I think back on page 4, there probably needs to be reference to that. It just says means the district court, and I can look at Title 5 real quick to see how that's defined, but this is the only place, the only time the word commissioner appears in this bill draft is right here.
Yeah. Representative Craigo?
Thank you, Madam Chairman. I appreciate consistency, but I think for the purposes of clarity, it might be easier just to leave it the way it's written, which is district court and district court commissioner. So there's no confusion at the court level on who they can disclose the information to. And I appreciate your comments, and you are correct, but this is very clear. The district courts and the commissioners. And if we change it to just say courts, then as Mr. Fuller says, then we have to go back and make sure we include some sort of clarifying language back in the definition, which we really don't need to do if we just leave it just like that right here.
I'm preparing my brief now. Just kidding. No, I do think that instead of changing it on page 15, do you think, make a placeholder and consider adding to the definitions on page 4 of court, which would be court commissioners as well, Mr. Fuller?
Madam Chairman, the other thing to consider maybe is there is a separate statute that delineates what a commissioner can and cannot do,
Right.
presumably which would apply to which does and would apply to these proceedings already. So, whether that needs to be clarified in this title, I'm not sure. In terms of whether court means district court commissioner. I think a district court would follow 53307 in determining what a commissioner could do in these cases.
Thank you. All right, moving on to page 17, staff comment there. Any action by the committee? Okay, moving on to the second staff comment on page 17, the committee may wish to consider whether language is needed that states the disclosure must also be permitted under federal law. Any action here? Okay, turning the page. Page 18. This is the term aggressive patients. Comments from the committee? Ms. Somerville, I think last night we discussed this issue. Do you have a better definition maybe for us?
Madam Chairwoman, we had discussed some definitions with the word violent or violent behaviors. What we're actually going to recommend comes from the Department of Health in the Life Resources Statute, is recommended to me by the director to change it to placement of patients with exceptionally difficult behaviors. Currently, that's already a statutory term, and that would be concise and understood.
Representative Craigo?
Where might we find that definition?
It might be in his handout here.
Madam Chairman, Representative Craigo, I'll look it up. I believe it's Title 25, Chapter 5 for the Life Resource Center, where that was established through the Facilities Task Force a couple of years ago.
Madam
I
Chairman.
would-
Mr. Fuller?
Yep, 255102A31.
Madam Chairman, I may just mention for the committee's awareness, that is not really a clinical term, but since it's operating in statute right now, and I think understood by facilities of the broadness that that carries, it works here.
Mr. Beaver, did you hear that? Do you have any comments?
Yeah, we don't have any problem with the Somerville suggestion. That's fine.
Ms. Somerville, would you repeat that term? And I will need a motion from a committee member if you want to change it.
Madam Chairman, on line 12, page 18, we would change it to including the placement of patients with exceptionally difficult behaviors.
Is there a motion? Moved by Representative Wanitzer, seconded by Senator Cost. Further discussion? Representative, anybody online? Further discussion from the committee? Sensing you're ready for the question, all those in favor say aye.
Aye.
Any opposed? Okay, that motion has passed.
Madam Chairman.
Representative Yen.
So in the same subsection, Roman at 3, is the in good faith something that's already in existing statute? Because it seems odd that we would put in good faith here and not anywhere else, and is it necessary at all?
Representative Yen, in my opinion, I think it could be, it's not uncommon to see those types of provisions, but particularly contracting in good faith, but I think it would be fine to remove it. I think the department is, all contracts are to be negotiated in good faith already. So having that expressly stated in statute probably is unnecessary. Further, Representative Craigo?
Thank you, Madam Chairman. I guess question for Mr. Fuller. I think that's in the existing law, is it not?
Madam Chairman, Representative Craigo, at least in Title 25, it is not. I could only find 2 references to good faith. I think the reality is, the department's going to have to contract, in accordance with state procurement and current state law anyways, to where, whether that's in there or not, and as has been discussed, is, something that's required for contracts anyways.
Right. You have a motion, Representative?
Madam Chair, I'll move to strike it. We don't need unnecessary language.
Is there a second?
Second.
Seconded by Representative Larson. All those in favor say aye.
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 Give you a few more minutes. Anyone else? All those opposed say no.
Oh.
Okay, division being called. All those in favor, please raise your hand. All those opposed, please raise your hand. That motion passes. All right, let's turn the page, bottom of 19. All right, how's everybody doing? All right, so we are establishing a medication review committee. So not later than 180 days after the effective date of this section, adopt rules in accordance with the Wyoming Administrative Procedures Act and establish and administer a medication review committee that consists of not less than 3 members, all of whom are licensed to prescribe medication. They shall convene promptly for review after request from a patient's physician. The committee may wish to consider whether a treatment coordinator or someone else can also request a review by the medication committee. And looks like the staff comment identifies whether or not the committee should develop those requirements or if the Department of Health should specify them through the rulemaking process. Which certainly seems prudent. Representatives Wanitzer?
I just want to make sure I read this correctly. So the primary physician of the patient asks, and then I assume you have to have 3 other people licensed to prescribe meds. So we're talking 4 physicians here. Do we have, I suppose they have that many at the state hospital, but I'm not sure at other places trying to get a 3 people authorized to prescribe medicine that aren't the primary physician, that just seems very difficult in certain instances, in certain parts of our state and certain facilities. I know how tough it is to get two psychiatrists in the state at the same place at the same time. I know there's some other medication prescribers, but of psychotropic meds, I struggle to see how, the way I read this, you're going to get 4 licensed psychiatrists or people with that level of prescription authority to have this type of review that's not extremely expensive.
I think helpful for the committee to review the comments provided by the county attorneys. One, the county attorneys have no opinion on who should be able to request a review of the medication. And they do believe that the Department of Health should adopt rules rather than the medical review committee adopting its own requirements. And if we look at what comments the Department of Health provided, that's on the bottom, that's number 15. The Department of Health is unclear what the full intent of the Medication Review Committee is and is therefore unsupportive of the section. Courts currently have the authority and ability to prescribe involuntary medication administration based on the evidence presented. They're concerned about stripping this authority away from local control where there is more timely and tacit knowledge. Period. Often the problem that courts and providers run into is taking on the liability of ordering involuntary medication administration and having the appropriate professional who can administer it. Representatives Wanitzer.
So, Madam Chairman, I guess I would move that I'm trying to think where I would start striking, but I guess it would be lines 4 through 15. Well, and on the next page, I guess I'd go all the way through line 12 on page 20. Just wipe that all out for the current time, and I would imagine after a couple months we can figure substitute language in, but just take out the review committee at this point altogether. That'd be my motion.
So the motion is by Representatives Wanitzer to remove the concept entirely of a medication review committee. Is there a second? Seconded by Representative Oakley. Mr. Beaver.
Thank you, Madam Chairman. I believe this was taken from a model of other states, maybe more workable due to additional resources that Wyoming would struggle to have. So if it's not going to work in Wyoming, then it shouldn't be in there.
Yes, Department of Health.
Madam Chairman, thank you. I have a bad habit these days of not making friends everywhere. So I want to be clear that with this provision, we're not trying to simply get rid of it. It was really the intent. What it looks like it is written right now is that we should adopt rules that establish the committee. There's not really a direction in the legislation for what action that committee would or wouldn't take other than reviewing requests from physicians. So it was more about what that review would produce in terms, was it a recommendation? So when we went through the go through the rule promulgation process, we would struggle to find applicable law to base those rules on as this is written. But the points are well taken that have been discussed that, as I mentioned last night, I'm not sure the resource would exist currently in the department and could add time to the commitment process for medication administration.
Representative Washit.
Thank you, Madam Chair. What happens presently if a patient's physician has a concern about court-ordered medication? Does that physician have standing to call for a court review, or what happens presently?
Madam Chairman, Representative Washit, that's a great question and probably beyond my expertise. I think in the civil commitment process, as I understand it, a court will consider testimony or evidence from a variety of different individuals, whether it's the law enforcement officers who made the detention, emergency room physicians, mental health professionals, psychiatrists, and potentially a patient's physician if they're available and can make comment of medical contraindications. And a lot of that happens within the healthcare system, relying on medical records, but it's probably highly variable on how that works. Again, kind of beyond my knowledge, but to the previous discussion about where recourse exists for individuals in other parts of statutes, I think that would likely exist in medical malpractice and what individuals have in the ability to take action either civilly or criminally against medical treatment that was given that was inappropriate or damaging.
All right, thank you. Further discussion on the motion? All those in favor say, oh, Representative Provenza?
Yeah, Madam Chairwoman, I just have a quick question and I apologize if this was answered in discussion of this bill. Can the Director of Health tell me how many Title 25s are issued? Because we heard from a county attorney earlier today that they handle this almost daily.
Madam Chairman, Representative Provenza, what I can tell you is how many involuntarily hospitalizations have been ordered year over year. We can provide that data. The most recent year, I believe, was around 230, 240. But to be clear, and Mr. Beaver could weigh in here, we don't have visibility on the numbers of emergency detentions or continued detentions are ordered. It's really after 72 hours when we become responsible or take over financial responsibility, or if a court issues an involuntary hospitalization order that we essentially get the information.
Thank you. Representative Washit?
Thank you, Madam Chair. I was wondering if Mr. Beavers might chime in on my question a moment ago about what happens currently, because this language calls for the patient's physician to request his medical review committee. So I'm envisioning a scenario where the patient's doctor thinks that the medication that's been ordered is improper and wants to have it reviewed. What happens presently? What's the process for a patient's doctor to get the court to reconsider court mandated medications?
Mr. Johansson, if you know Mr. Beaver?
Yeah, Madam Chairman, Representative Washit, currently that doctor would contact the county attorney and we would set up a hearing with the court. The doctor would explain to the judge what he is seeking. And the judge will be very uncomfortable because he'll say, I'm not a doctor. This is outside of my area of expertise. That's how that works now.
All right, back on the amendment. All those in favor of Representative Swanitzer's motion to remove any reference to a medication review committee, please say aye.
Aye.
Any opposed? All right, seeing none. Moving on to page 20. I think this has been removed as well. Because this is part of the medication review committee, correct? Everyone sees that correctly? All right, page 22. Give everybody a chance to reorient themselves to where we are in the bill draft and review that comment, or I could continue to read it for you. But I'm sure you might be getting tired of hearing my voice. Hoping you are.
So, Madam Chairman,
Representative Bonitzer?
with the staff comment about just putting this in rules and regs instead of statute, I think I fundamentally agree. But then I'm not exactly sure if my motion would just be to, it'd probably be almost conceptual to take the specific statutory direction there on the top of line 20 or page 22. And I don't know if the Department of Health would need specific rulemaking authority above and beyond what they already have. I guess that might be a question if they feel they need greater rulemaking authority, or if we just take out the statutory construction, really 1 and 2 on the top of page 22. And just end it on 21 at 22 that says the department shall adopt rules and regs. However that works conceptually, and statutorily with a framework. That's my motion. I know that was roundabout getting it.
Let's make it more concise and louder.
So Madam Chairman, my motion would be on, I'm just trying, I mean, it's so specific on what I think should be in statute and what I think should be in rules and regs. But I guess I would say that we would strip out all of I'm at a loss if Mr. Fuller wants to help me out.
Don't you love your job, Mr. Fuller? Mr. Fuller, maybe help explain, I don't know why it's loud, the staff comment. Kind of reorient us to where we are and then
Sure.
help us drill down on how we can implement the staff comment in the bill draft.
So there's two pieces here. The first piece, which I believe is what Representative Zwanitzer is getting at, is just a question of policy versus rules. And if that's, that simple, that issue would be, I think, as simple as just saying rules instead of policies on page 22. And honestly, I'd probably delete that subsection B entirely and just move it into subsection A. The second piece of it is different. And that really, I think, gets to paragraph 2. So page 22, lines 5 and 6. There is a current statute, there's 2 in fact, that deal with the voluntary applications for admission and when voluntary patients shall be discharged. This bill draft, and certainly, I think a decision for the committee, a policy decision, but this would delegate that entirely, that process for voluntary admission and discharge to the Department of Health. So that's really, I think, the policy consideration for the committee to consider in terms of that delegation. But the first piece would simply be rules versus policies.
Representative Zwanitzer, what Mr. Fuller said first is your motion, is that right?
Yes, Madam Chairman.
Were you able to capture that? Mr. Fuller, your connection to the removal of B and
So Madam Chairman, I think it would just be delete lines 20 to 22 and renumber as necessary. It would renumber those paragraphs to just to be subparagraphs.
so on page 21, lines 20 through 23 to remove. And then renumber as necessary, is that correct? Representative Zwanitzer says yes.
I just want to make sure then, Mr. Fuller, the remnants 1 and 2 on the next page, lines 1 and 5 would just become 4 and 5.
So it would be, I don't think it would be the 4 and 5 subdivisions. I think it'd be subparagraphs D and E or C and D because we deleted the medication review.
Now I'm totally on board with that motion, Madam Chairman.
Is there a second? Seconded by Yen. Representative Washut.
Thank you, Madam Chair. I seem to recall yesterday the doctor from WBI, when he was testifying, said that the state hospital did in fact have a process already for voluntary admission to the state hospital. And the problem was that there was a prioritization of involuntary committals, which put the voluntary folks at the end of the list. Maybe Mr. Johansson could speak to that.
Mr. Johansson?
Madam Chairman, Representative Washut, that's right. There is a statute, as Mr. Fuller mentioned, governing voluntary admission and treatment at the state hospital. What I offered in our comments on the staff comments that I sent to you all this morning is there's law, rule, process, and reality, and sometimes they're at odds with each other. There is, as everyone will attest to, a lot of demand for beds at the state hospital. We operate a waiting list currently. We're optimistic that waiting list will come down significantly when we finish construction at the Life Resource Center. but the amount of voluntary admissions directly to the state hospital from other places is extraordinarily low, because there's so much demand on the Title 25 and Title 7 side for those involuntary areas of treatment. If this were to go into place, we will most certainly build on our current policies for voluntary admission when they happen, and articulate them, whether it's through rule or policy, whatever this law dictates. Just want the committee to be aware that it's not something that will likely increase the amount of voluntary patients at a state psychiatric institution for the reasons I mentioned. And also going back to the facilities task force that I referenced before, the state hospital and the Life Resource Center have recently been significantly remissioned, where the state hospital, the legislature passed should be an acute stabilization facility, prioritizing involuntary hospitalizations, Title VII services for forensic evaluations and treatment. So again, that's really the primary mission of the state hospital now. There are times when certain types of commitments at the state hospital do convert to voluntary based on a few legal and also clinical criteria. So it does happen, but direct admissions to the state hospital for voluntary patients is exceedingly rare.
Further discussion? Question being called. All those in favor of Representative Zwanitser's motion, please say aye.
Aye.
Any opposed? All right. Further discussion, Representative Zwanitzer.
No, Madam Chairman, I just think, I'm sure Mr. Fuller will cite it correctly, and conforming it would be establishing a process on line 1 and on 5, establishing a process to be the new C and D. I'm sure he'll do that. So no other comments on this portion of the bill for me.
Committee, are we ready to turn the page to page 23? Okay. And committee members, I'm reconsidering my decision for a quick break. That said, how are your time? Are all of you okay to stay maybe till 5 and work this bill through? Yeah. And on Zoom, you guys okay? Representative Parsons looking a bit vexed. It is tough. So I'm thinking a break might be good for us too. Either we quit or we just take a quick break. As the chairman, I'm going to go ahead and call a quick 10-minute break to kind of reorient us. We'll come back at 3:10.
Thank you.
Sure. I just checked out. I was like, yeah. And we are live. Welcome back from the break. We are refreshed, right? And we are ready to keep working through this bill. Thank you. I think one notable piece is there are a lot of staff comments in this bill. And what that indicates is the level of work that LSO has put into this bill. That has been an immense piece of work. We want to thank you for that level of careful review to help us feel more confident in the work that we are creating. And so we appreciate that and recognize we have a lot of work to do, but it's because we're doing good work together and you are doing such good work for us. So thank you to all of the attorneys and others who have reviewed this bill draft and provided us all of these staff comments to work through. So at that, we are on page 23 on the staff comment 20 to 24. And it appears that the staff comment indicates that we do not need that provision because WAPA already requires it. And so the subsection C, who would like to adopt that staff comment?
Madam Chairman, I would move the staff comment deleting, what is that, 12 through 14 in Romanet 6.
So that's on page 26, or I'm
23.
sorry, page 22, lines 26, all the way through page 23, line 14, to remove those provisions. There's a second by Senator Cost. Further discussion? Representative Crago.
Thank you, Madam Chairman. So I don't understand the staff comment, but I'm not sure that the items contained within lines 6 through 10 is actually required by the APA. I mean, I know we do that under current statute, but I don't think that would be required under the publishing comments of the APA.
Okay, further discussion? Mr. Johansson, Director.
Thank you, Madam Chairman. If I may, to Representative Crago's comment, he's absolutely right that that is not part of the rule promulgation or notification process. I will mention to the committee that in terms of a network of providers that we either contract with or pay, that is not static. We can certainly provide that, our designated hospitals that have provider agreements or enrollment agreements with us. But when we try to place a patient that either has high medical needs or difficult behaviors, things of that nature, we do reach far and wide and see if there's a provider that kind of at that moment's notice will agree to take the patient, admit the patient, and then we work out payment. It's certainly not perfect. And I understand the intent of this because it's a big frustration in the communities to be able to know what is the provider network that we can use in Douglas or whatever that might that community might be dealing with. But just wanted to provide that caveat. We're happy to comply with a provision like this, but it's quite dynamic from day to day or week to week.
So, Director, do you then support the amendment to repeal or to remove these particular provisions?
Madam Chairman, ironically, with what I just said, I do support that provision.
Okay, thank you. All right. Question being called. All those in favor of Representative Swanitzer's motion, please say aye.
Aye.
Any opposed? All right, that motion has passed. Page 24. Okay. Again, in some of these staff comments, aren't indications that there is a legal concern. It's just maybe there might be a better way to do it or some other options available. This would be one of those. So the committee may wish to utilize the standards for procurement and capital construction as it relates to capital project funds for a special revenue account. Thoughts about that? The wisdom of doing that, whoever thought about the staff comment, just consistency within our statutes? Representative Swanitzer?
Well, Madam Chairman, I actually do like that idea. It's a special revenue account, and when it goes before the State Building Commission, which I sit on, this is at least in the last 5 years, it's been a very hot topic almost every commission meeting of what are our expenses? What are we building? It's especially at the state hospital, it's mostly general funded. And so I like to think it has been a special case. I'm not sure in the future if it will continue to be, but at least for the upcoming biennium or two, I think the current language in the bill is better than just turning it over to how we manage other state buildings.
All right. Moving on to page 25.
And Madam Chairman, for this staff comment here, I think there would need to be at a minimum a conforming amendment to be given the deletion of the medication review committee.
And Mr. Fuller, do you believe that you have the authority to do that based on our previous amendment where we removed the medication review committee, that this would be conforming to deal with that here? Yes, okay. And so this staff comment is also handled. All right. Turning on to page 27. Okay. So what this staff comment has to do, I think, with is on page 26, line 17. Each treatment facility shall admit persons seeking voluntary admission for treatment. So that's an interesting concept. I think what that staff comment is intending to address, that the treatment facility does not have the discretion whether or not to admit a person seeking voluntary treatment. Representative Zwanitzer?
Thank you, Madam Chairman. On page 26, I think for the current time, I like leaving the language, but I do believe on line 17, it should be may admit persons seeking voluntarily admission for treatment. As we've heard, we don't have a lot of space in certain facilities, both state-owned and private right now. And I just think the word shall it's easier as may. So that's my motion on line 17, page 26, change shall to a may.
And I would just direct the committee's attention to comment number 21 on the Department of Health's handout. That's where we are.
What do they think?
Okay, so there's a motion. Is there a second? Seconded by Cost to change the shall to a may on line 17. Discussion?
If we already have language elsewhere in statute dealing with voluntary admissions, can we just strike all the language about voluntary admissions out of Title 25?
Mr. Fuller, do you know?
Madam Chairman, Representative Washut, I don't think in this bill draft there's a specific section in the draft for voluntary admissions like there is in current statute. So I think this is one of the few times it is referenced in this bill draft. So, it may be worth at least keeping, the concept in the bill draft. Of course, that's certainly a decision for the committee.
Yeah, Representative Craigo.
The other thing I guess I would say, Madam Chairman, is that there is a deeper policy issue here, may versus shall. And I can tell you from the county's perspectives, it is hard to get people into these facilities. And if somebody is willing to go on their own and show up, sometimes what we have an issue with is that person may not have any, they may not have insurance and they may not have the money to pay. And so sometimes they get turned away. And I'm not saying it's because they do or do not have money to pay, but it could be. And so I think, and Mr. Beaver may chime in here in a second, but I think that's why they chose the word shall for this particular paragraph. And if you read on in the paragraph, it says, if they don't have an available bed, they can direct that person somewhere else. But if they do have an available bed, then the person who shows up voluntarily should be admitted. And I think that's the purpose of the language.
Representative Rodriguez Williams.
Thank you, Madam Chairman. just to add to the further discussion on the amendment, I'm in favor of leaving it as a shall, but we did hear testimony from Ms. Summerlin, if I remember correctly, that there was a recommendation, forget if it's in line 22 or 23, to add meets admission criteria to that last sentence.
Representative Zwanitzer?
I just want to make an amendment to my amendment and also make the shall on line 20 a may. I'm not sure if it's, I don't want a statutory responsibility for a treatment facility to have to refer. I guess that mean it just allows them to turn people away and say, we can't help you, which I don't think is right, but I'm hoping there are other community resources. But for the sake of statutory construction, I believe the words may on line 17 and may on line 20 are better for the statute.
Senator Cost supports that. Senator Cost, further discussion?
Thank you, Madam Chair. I know also yesterday there was talk of probably putting in that it's the clinical ability to accept the patient. In other words, the hospital needs to clinically have the ability to accept a patient before they can say, yes, I'm going to accept it. Because if it's a certain type and they can't accept that, or they don't have the provisions for that. That was brought up yesterday.
Further discussions from the committee on Representative Zwanitzer's motion to change the shalls to a may. Question being called. All those in favor, please say aye.
Aye.
All those opposed, say no.
No.
All right, chair is in doubt. All of those in favor, please raise your hands. Raise your hands. Raise them high. And all those opposed, please raise your hands. Right, that motion has failed. And I probably should have done this before the motion, but Mr. Beaver, do you have some comments about this topic of the shells to a may?
Madam Chairman, Representative Cargo accurately described the intent behind the language.
And do you agree with that, or are you kind of just representing, you know, the will of the association?
That's based on what we heard last year in the interim when we met with all the stakeholders and we had extensive discussions on these issues. And you heard it again from Dr. Martirano. They estimated, I believe, 30% of Title 25 could go away if voluntary admissions were handled in a better manner. So that's where it comes from.
Director? The other director?
Thank you, Madam Chairman. Interim Director, slight correction. This is a tough one, and Representative Crago's point is very well taken. The intent here is to put some teeth behind law or direction for our contracts that facilities need to or have to accept these patients. Now, language now that's being discussed, I think in reality, there will be ways for facilities to deny admission. We don't have an available bed. We don't have a clinically appropriate bed. As an amateur economist, what I would tell you is it really comes down to payment, something that's not being considered, and rightly so, within the context of this bill, that if you have a Title 25 client who may be willing to switch over to a voluntary admission, but is uninsured, doesn't have a pay source, and the state hospital is full with civil commitments, but there's a facility that would take them if they were cash or fully insured. If there's not a pay source behind that voluntary admission, it's likely not going to happen. And since the person wouldn't be subject to the Title 25 proceedings anymore, the county and state financial responsibility wouldn't be there. So again, the intent's well taken here. It comes down to a resource issue in these cases.
Okay. Committee members, you heard Representative Rodriguez-Williams' comments about the need to provide maybe additional amendments. Representative Rodriguez-Williams, did you want to make that into a motion to adopt that language for meets admissions criteria.
Madam Chairman, yes, I move that we add on page 26, either in, well, I guess we would squeeze it in the middle of line 21, and add meets admission criteria.
Does everyone understand that motion? So I think on page 26, on line 21, so the line would read, refer the voluntary admittee that meets admissions criteria to other available and reasonable treatment options. Is that correct, Representative Rodriguez-Williams?
Yes, Madam Chairman.
Representative Oakley? Is there a second for discussion? Representative Oakley seconds, and now for discussion.
Okay. Thank you, Madam Chair. I guess I understand the intent, but the problem I see with adding that is that it has an underlying requirement then that the person has been evaluated, which if they don't have, the facility can't take them. They don't know if they meet the criteria or not without evaluation. So it seems yeah, inappropriate, but what, like, it would already require the knowledge that the voluntary admittee meets criteria. We don't know that because this facility doesn't have isn't able to evaluate or take.
Madam Chairman, if I could follow up on that, right? We're putting the onus on the treatment facility to make a decision on, well, A, what else is available? And there might be some resources, but with reasonable treatment options, they might not know what the patient needs are. And I don't want them to be stuck on saying, you were required to send them to somewhere that could meet his or her needs without truly a diagnosis. I thought my amendment was so darn good a second ago.
All right, further discussion on Representative Rodriguez-Williams' motion? Seeing none, are you ready for the question? All those in favor, please say aye.
Aye.
All those opposed say no.
No.
That motion has failed. All right, moving on to page 27. This concept of the committee may wish to consider whether there is a situation where a voluntary admittee may need to be placed in emergency custody. So this has to do with the treatment facility shall not place a voluntary admittee in emergency custody. So is there a circumstance where a voluntary admittee would need to be placed in emergency custody? So Representative Washit?
I guess it kind of comes down to the definition of a voluntary admittee. If that voluntary admittee suddenly decides he's going home despite all sorts of concerning behavior, is he still a voluntary admittee, or do we just go back to square one where we have an individual who may be in need of involuntary hospitalization? And so my sense is that at the point that a voluntary admittee needs to be placed in emergency custody, at that moment, he's no longer a voluntary admittee in all likelihood, the way I read it.
Further discussion? Representative Zwanitzer.
Thanks, Madam Chairman. I mean, I think if you come in voluntarily and say, hey, I'm hearing voices and I feel whatever it might be, that I might be a danger to myself or others while you're still in the right state of mind, and during however long you're there through the administrative procedures of checking and diagnosing you, something happens. I think a treatment facility should be able, what are they going to do if they have an incident? Call the sheriffs and have them transported somewhere else? And then they can place them in emergency custody? I think they need that option in my mind, but someone tell me why I'm wrong.
Director.
Thank you, Madam Chairman. This issue was discussed at length years ago in the Title 25 subcommittee. And again, as with everything here, it's difficult to decide what the best option is. I think at least my guidance to the committee would be this is a balance between having that option available when someone might actually manifest those behaviors that are dangerous and that emergency detention is needed, with deconflicting or having fewer conflicts of interest. So if you have a facility that provides these types of services, psychiatric services, that is also taking voluntary admissions and deciding clinically when the person wants to walk out the door that, well, no, you're dangerous to yourself or others, we're going to initiate Title 25 proceedings. The idea is to have a check against that. And current statute, does that to a certain degree with, county attorney has to agree to file all of these different steps of the process. With the gatekeeper, what's referred to here as treatment coordinator, I think the idea from the legislature years ago was to, insert a different community entity into that as a recommendation to the court that this person does or does not, in our view, that is separate from that facility, warrant symptoms for involuntary hospitalization. I don't have a great recommendation for you. I see the certain scenarios where that option would be warranted so that that facility doesn't need to call law enforcement to say, will you start what we call a 381 form on this person when they're the medical provider in that situation. So it's a very difficult issue, but probably just made it more difficult for you.
Representative Washington.
Mr. Hampton, isn't it accurate in earlier parts of Title 25 where it says that either a peace officer or a medical provider can order an emergency detention? So that medical provider who's present could do the same thing that the deputy sheriff could. We just don't need to have the deputy sheriff because this guy's already inside the hospital, correct?
Madam Chairman, Representative Washit, that's correct. And I believe in our comments to the committee, within the context of this bill draft, we felt this section would not be needed for those reasons, because the authority already exists. If you're a physician or an emergency room or a law enforcement officer, today you have the ability to initiate those detention proceedings.
There is no motion. Representative Zwanitzer?
I would say some of my concerns are assuaged when if you read further down, and I guess it's Romanet 4 on page 28, if they're going to leave the treatment facility, then apparently you are allowed to put them in custody, which I don't quite understand. They have to try to, this happened in my family, right? We went in for a simple psych diagnosis and they wouldn't let us leave and they committed my kid. But so I don't quite understand how that works. You can't, if they try to leave the facility, then you can put them in emergency confinement. But as long as they're not voluntarily wanting to leave, you can't. And I guess I'm trying to figure out where that fine line or that gray area is where people can and can't be put in emergency custody. As long as they agree not to leave, they won't be put in custody. So then you just have them stay at your facility. I can imagine why it's contentious, because I don't understand in the real world situations how exactly this would work is my difficulty. And maybe a county attorney who's had to deal with this can give me an example of, it's my understanding this is current law.
Mr. Beaver?
Madam Chairman, I'm kind of struggling to keep up with where we're at. Could you restate the question?
So, Mr. Beaver, we are on page 27. And we're really focusing in on line 17 through 18.
Madam Chairman, as I put in my notes to you, you're either voluntary admittee or you're going to be in emergency custody. And it's not uncommon for patients to transition back and forth, particularly as an example, our facility here in Sheridan that the Veterans Administration runs has a psychiatric unit veterans come there voluntarily, receive treatment for some period of time, and then decide they want to walk out the door, then they become a Title 25 case. So, you know, it's just not an issue as far as I'm concerned with the language there. But maybe I'm missing something Mr. Fuller is trying to point out that's just going over my head.
So, Mr. Beaver, I think the situation is your legal understanding of what these terms mean, as opposed to how it would work on the ground. And I think how the committee is interpreting these provisions is that a treatment facility, you know, can't try to do a runaround on how that patient's care is being paid for, or their control over the patient, I believe. And that is not actually what your intent is. Your intent really is this understanding of these different legal statuses associated with what a voluntary admittee is, and someone who is in emergency custody or involuntarily hospitalized. So I think we have maybe some miscommunications happening potentially, and intents not being fully understood with the provisions. So perhaps maybe Mr. Beaver, share with us what the county attorney, what the association's intent is by having this be in statute.
Well, Madam Chairman, lines 17 and 18 would be an attempt to prevent a facility from doing some cost shifting, basically taking a voluntary admittee and saying, well, the paycheck isn't there, let's make them a ward of the state. So that's exactly what that's intended to do.
Okay, so let's think about that goal. And one, if we want to achieve that goal, and then two, is there a better way to word this to accomplish that goal? So let's talk about the policy behind it first. So do we want to put in statute that the treatment facility cannot do a cost shifting effort, and because the patient runs out of money or the insurance runs out, that they then go into emergency custody to have the county or the state pay? Is that a policy that we want in place? I mean, from a patient perspective, I could see why that's helpful, right? Because then the patient continues to have care as opposed to being removed from a facility for a failure to pay. So policy around that. So we could be harming patients by having that potentially. But the counties may want that in there. Representative Washit?
I think that is a wise policy. And I think we could simply say before place of voluntary admittee and emergency custody, include the words for purposes of cost shifting, comma, place of voluntary admittee and emergency custody.
Well, I think their purposes would be for patient care. I mean, so really, I mean, I don't believe that any of the facilities, they don't have a problem with volume, right? There's no lack of demand for the services based on what we hear. The issue is that the patient comes in voluntarily, their insurance covers for X amount of days, the patient needs care beyond that amount. What does the provider do? Does the provider say, listen, you're not quite well yet, but you have no more coverage, and so see you later? Or do they try to change the legal dynamic so that someone else pays? So their purpose, I believe, is patient care. Their purpose, I don't believe, is trying to get the county to pay, I believe. Yeah, please come forward, Ms. Schickik.
Thank you, Madam Chairman. Mary Lynn Schickish, representing the 4 Banner Health Hospitals in Wyoming. As you probably all know that I do that at this point.
Maybe a different introduction.
And thank you all for your graciousness last week. I truly appreciate it, or 2 weeks going. I'm just getting up to speed on this issue, so please take what I say with just to try to understand where we're going with this. And speaking more specifically to Casper as opposed to the other Banner facilities. Many potential involuntary commits are brought to the emergency room at Wyoming Medical Center. And those include patients from well outside Natrona County. Many do. As I'm understanding the process, it's currently changing a little bit, and we want to engage with you and want to be very much a part of helping you make good decisions on this. So we have committed, and I told Senator Nethercott at the break that we're going to get engaged with you to help try to figure out how to best manage this problem. And I will say as an aside, is I think it just speaks to the whole issue in Wyoming and throughout this country of states struggling to have a good mental health policy and a way to fund it. Many of these patients don't maybe necessarily qualify, but in fact, they do need other significant services such as alcohol detox centers, which we don't typically have around the state, except maybe in certain locations. So specific to Title 25, a patient would come into the emergency room, be brought in by law enforcement, whatever, and be put, if they're an involuntary hold. So they would be brought in, they would be in the 24-hour process, and there's a new system that has been put in place because there's not local services right now making these services available at Wyoming Medical Center, which does not have an inpatient psychiatric unit, does not, as best I know, employ a full-time psychologist. They do have social workers on hand, but they do have to have that evaluation. So a recent Banner Health behavioral health program located in Colorado is doing telehealth evaluations of patients. My understanding, I could be corrected because I'm going to get this information, a voluntary admission, as Senator Coswell knows on a hospital board, would need to have a criteria for needing admission. It's not that a hospital wouldn't want to necessarily voluntarily take a patient, but they may not need inpatient services. So I hope I'm explaining to you, you typically have to meet a criteria, even if that patient had insurance, he or she might not have met the criteria in order for payment to occur. So you could potentially suggest that you want to statutorily have those patients be admitted no matter what, and there not be a pay source. And I do need to say, as part of the, this is really going to complicate it, but as part of when Memorial Hospital of Natrona County existed, this is in Casper, until 1986. In 1986, a 501c3 Wyoming Medical Center leased the assets from the county. At that point, as in lieu of paying rent for the hospital, the Wyoming Medical's 501c3, Governor Mike Sullivan was the chairman of the board that created all this, agreed to pay all of the indigent care, including prisoner care, including involuntary hospitalizations, everything, all indigent care. In the current arrangement now, we Wyoming Medical Center and the other facilities, I don't know about the other, I should say, Wyoming Medical Center does not charge the county or anyone else. They provide that indigent care for the Title 25 patients. So we're a little different wrinkle. I want to make sure people understand that. Even though, having said that, I hope I'm being helpful to this conversation. A voluntary commitment wouldn't be covered by insurance if there was no, if the situation didn't warrant an admission. And a physician or physician assistant or a nurse practitioner would have to evaluate that particular patient. I hope does this help explain the circumstances with hospital admissions?
Yes. Representative Washit.
Thank you, Madam Chair. Ms. Shikish, if the individual would meet the criteria for an emergency detention to be taken into emergency custody, they would probably also meet the criteria for medical care, correct?
No, not necessarily. So Wyoming Medical Center is taking these patients who don't meet medical criteria. That there are some that have coexisting conditions that do need medical treatment as well, but they don't, in most instances, meet the criteria, but that they are an emergency involuntary hold, so they're required to take them. There isn't currently any other facility that takes them. So there's a real big difference between a medical necessity and a psychiatric necessity. So in terms of just, I think we really need experts who are sort of what in the insurance field to help explain this somewhat. But you could present at the emergency room, as you all may have in the past, and the determination was made that you did not need an inpatient stay. Some patients are admitted on an observation basis, but they're not necessarily required, there's not an admission criteria that warrants admitting them to the hospital. And this is a bit of the complexities of this, is that some of the patients do have medical conditions that do require hospitalization as well. And I think this speaks to what I tried to allude to, which is that unfortunately, we have a lack of services in the state, as do many states, to accommodate these situations. There has been, as I understand it, I'm not in a position to comment on it specifically, but there was this element of these crisis centers bubbling up the last couple of years to help handle some of the potential Title 25 involuntary patients. For instance, I think at one point there was a facility in Casper that was doing that, but I'm not aware if they're doing it anymore. Sorry for confounding the situation,
really
Madam
great
Chairman, but
bomb.
I'm trying to
Thank
be
you.
helpful.
We appreciate you blowing that up right here. Mr. Fuller? Senator Kolb?
Thank you, Madam Co-Chair. Yeah, just getting back to page 27 in the lines 17 and 18, wouldn't there be instances where that would be a public safety issue, where they had seen a situation where it was voluntary, then it would necessitate emergency custody? I mean, wouldn't those situations exist to the folks out there who are, if I understand this correctly? I'd like to hear the answer. Thank you.
Ms. Shinkick, if you can.
Madam Chairman, Senator Kolb, I think you have a great question, and I really don't feel completely knowledgeable enough to answer it, except that I will say, I think in certain situations throughout the state, some of those folks are moved into a situation where they're incarcerated. So not needing any medical attention per se, that they aren't necessarily placed in a hospital. But if a patient, I guess if a patient is at severe risk, we really need some physicians and others here where they're potentially suicidal in their voluntary basis. If they don't meet acute care medical necessity, I'm sure that the physicians probably make those decisions on a case-by-case basis. And in those instances, the hospital would be in a position to just, as they do with many of these these Title 25 patients, eat the cost per se. I hate to use it that way, but they would in fact probably take them. But I think every hospital in the state would be different in terms of how they would handle it, particularly if they're governmental, non-governmental, for-profit, not-for-profit.
Dr. Schmidt, do you have some comments? I think we should have both directors come forward. Just take a seat. Let's all just get comfortable. We're just gonna have a good conversation. All right. Director Schmidt, welcome to the committee.
Thank you, Madam Chairwoman, members of the committee. My name is Corin Schmidt, and I'm the Director of the Department of Family Services, and I can't believe that I'm getting up here to talk to you about this. I'm going to come at the answer to what I think the question is from two different perspectives. One is a vulnerable adult. So as an agency that often engages with vulnerable adults that often present with these types of things, I think I would encourage you to consider keeping in a provision that keeps voluntary admissions as open as possible. My concern would be is that if you start to restrict what voluntary admissions look like, and in this case, then give the opportunity for that to convert into an emergency detention, may keep people out of voluntary admitting and then get into a place where then they're seeking services because they've come to the attention of law enforcement. So there is some practice in mental health services in some states where there can be voluntary admissions because they have people with serious persistent mental illness that do repeat. But if they can go in, if they know that they're about to experience a psychotic break, they go in, they get the treatment, they leave, and then they're not dragging everyone through the court system. So I'm just coming at it from more of a client perspective and a service delivery perspective in terms of access and not dissuading maybe potential access.
And to add to that, very helpful, thank you, is that you wouldn't often see someone presenting immediately, say, to WBI. They would be more likely coming to an emergency room in an acute care hospital and then be transferred over. So just that notion of a voluntary hospitalization, just as you wouldn't, and I would not, you wouldn't see somebody voluntarily go to the state hospital in Evanston. It's usually a movement through the process to get there.
Representative Craigo?
Just a comment, Madam Chairman, we do actually see people voluntarily go to WBI.
You do.
And then it happens quite a bit, because either law enforcement or their mental health provider will tell them, look, I'm gonna have to title you or recommend you for a title if you don't voluntarily go. So usually a family member gathers them up and they drive them from, say, Johnson County down to Casper directly to WBI for a voluntary admittance. And so it does happen. And then that's where this provision becomes very important, because once they have them at WBI, say they're there for 3 days, and it's obvious that they could be titled and they want to leave, but the healthcare professional knows that that's not a good idea. As soon as they leave and head back to Johnson County, we're gonna have to title them. And so rather than the way it's written now and the way I read it, and I understand this is really relating to cost, and it's a cost shifting provision is what we're trying to prevent there. But I think we need to think of some language that solves both problems at once. But anyways, just throwing that out there.
That's very helpful. Thank you. I know in Natrona County, they tend to go through the traditional acute care hospital system.
Mr. Beaver, do you have any comments?
I don't have anything to add, Madam Chairman.
Okay, Representative Washit?
Just following up, Madam Chairman, on what Representative Crago said, and one of the motivators for many of these people to self-admit at WBI or elsewhere is the potential impact on gun rights. And so in Wyoming, if you get involuntarily committed, not just detained, but involuntarily committed, your ability to purchase and possess firearms may be affected. And when you tell that to people, a lot of them are highly motivated to self-admit, get the help that they need without invoking the legal process.
That is correct, Representative Washington, but we do not report in Wyoming regardless. So, further questions on this topic from the committee? Committee, how are you feeling about what to do next? Representative Wannister suggests skipping ahead. Representative Crago?
So, Madam Chairman, I guess I would offer an amendment, and it sort of uses the language from the top of page 28 on Romanet 4, which actually when we get to that in a minute, but I don't think that one would be necessary if we adopt this amendment. So my amendment would be line 18, remove the semicolon and insert the following language. Unless the person is going to immediately leave the treatment facility and otherwise qualifies for emergency custody pursuant to the provisions of this act. And deleting Romanet 4.
All right, that has been moved and seconded. Discussion on the amendment? Representatives Monitor?
Just a question, if anybody knows, because the wording that we're taking out on Romanet 4 is medically unstable. And I don't know if that's a clinical diagnosis that someone has to make, or if that's a defined term in our statute when you become medically unstable. I just want to make sure if that language comes out. I don't like that language. I just also don't like deleting stuff out of statute without fully knowing what I'm doing. So seeing no one.
Why
saying
start now, Mr. Representative
Medically
Wannister?
unstable, a defined term, Mr. Fuller, do you know?
Madam Chairman, Representative Swanser, that term does not appear in the current statutes of Title 25.
Further discussion on the motion? All right, seeing none, all those in favor, please say aye.
Aye.
All those opposed, say no. That motion has passed. Okay, all right, let's turning on to page 28. We addressed that staff comment there, medically unstable, great work.
Can I quickly ask, probably one of the two people busily writing, how this practice works, if you're unconscious, when you come in, do they just put you in a holding facility until you're conscious and then involuntarily commit you? I I assume this is existing language, or Mr. Fuller, if you know, it just seems weird to me that if you get brought in, let's say from an overdose or alcohol, whatever it might be, you're not officially placed in custody, which I would imagine impacts that 72-hour hold until you're cognizant and fully aware of being able to be read your rights.
Mr. Beaver, this concept, when someone comes in under an emergency detention or some other scenario and they are unconscious, how is this handled? How is someone who is unconscious? Yeah, well, just walk us through that provision.
Madam Chairman, what we see is the patient comes in, if they're unconscious, typically by ambulance, they go into the ER. They will be kept in that hospital, that facility, until they regain consciousness. And as was noted, at that point, once they are capable of understanding what's going on, that's when the examiner would typically title them.
Representative Sponsor, I am not going to ask the question, who pays? There should be no question about who pays as we work through this bill at this point. All right, further questions? I think that we have managed the staff comment on page 28. Okay, now on page 29. So, kind of the statutory explanation of the role of the patient's attorney. And I think the reason for that is that there is confusion amongst attorneys who get appointed to represent these individuals for whether or not they are supposed to act in what they believe is the patient's best interest, as opposed to advocating for what the patient actually wants, which might be two different things. And they most commonly probably are. So the patient probably wants out so that they can harm themselves further if that's where they're at, which probably all other reasonable people would think that's not in their best interest. But that's not the attorney's role as the patient's advocate. There's probably a lot of confusion about that. Very difficult for patients' attorneys to do. I think that's probably why this is in here, Mr. Beaver. Is that fair? Mr. Beaver, you're on mute. Sorry.
Oh, I'm sorry, Madam Chairman, you are correct.
Mr. Beaver, do you think that this should be in statute really, or do you think that there's other ways for the bar or for this to be communicated to lawyers who are identified as being patients' attorneys?
I think this is the most effective and efficient way to communicate it is in statute.
And you think that it's important enough to be in statute because this is a continuing concern?
I have personally heard, well, every patient's attorney I've dealt with, the first question they have is, what's my role here? So yeah, it needs to be made clear.
Representative Zwanitzer?
Thanks, Madam Chairman. I'd just quickly point out on line 30 that we're going to delete all of that on the Medication Review Committee. And I hope end that sentence after the word chapter on line 29. Just making sure that's correct. And Mr. Fuller saying yes, so I'm ready to move on.
Okay, so we'll move along. So I think Representative Zwanitzer skipped ahead, maybe? That, for the Medical Review Committee again? Okay, And Mr. Fuller said yes. Okay. So back on page 29, any actions by the committee concerning these comments here? All right. Seeing none, moving through. Going on to page 32. All right, so this has to deal with reporting requirements of the Department of Health, whether or not this should be in statute or rule. So that starts on page 31. So let's review that paragraph on page 31, starting on lines 19. So do we want to leave that at the discretion of the department, or do we want it to be in statute? Representative Swanitzer?
Madam Chairman, I'm fine leaving it in the discretion of the department. I trust them.
All right, is there any further action from the committee? Any hands raised out on Zoom? All right, seeing none. Moving on to page 33. Representative Craigo?
This is not one of the staff comments, but I guess I'd like to ask everybody to look at it a little bit can we back up a couple pages? That's okay.
Sure, yes. I mean, I do think so. So just a timeout here is a great point of opportunity where the committee has a significant amount of work to do additionally. In this moment in time, we're just kind of focusing on the staff comments. We're not limited to staff comments, so we can go back. But I do think the next time we come together, which I think we'll have to do before we can adopt this bill in any meaningful way, we'll have our own amendments based on concerns we have identified or other stakeholders have identified that are not staff comments. So, but Representative Craigo, please proceed.
Thank you, Madam Chairman. So on page 30, line 8. And this is this subparagraph B says if the county attorney determines that a request to continue emergency custody meets the requirements and intent of this act, the county attorney shall file a petition in the language that's, I guess, catching me. And I think I'm not positive that this is current language or not, but it says in the interest of the patient. Is the county attorney actually filing the petition in the interest of the patient, or are we filing it on behalf? Our interest is something else, I would assume, is a county attorney's office, but.
Mr. Beaver?
Madam Chairman, that's the current language, and that's how every Title 25 case is captioned, is in the interest of Jane Doe.
Sure. It's the caption in the interest of. Okay. All right.
And-
Mr. Fuller?
Madam Chairman, Representative Craigo, current law just says proceeding shall be entitled. And perhaps, one option would just be a petition entitled in the interest of.
Do you have a motion, Representative Craigo?
So moved, Madam Chairman.
Seconded by Washit. Further discussion? Seeing none, all those in favor, please say aye.
Aye.
All those opposed? That motion is passed. Okay. Page 33, Representative Swanitzer,
Actually, if I can quickly go back to page 31.
31.
We're talking about when treatment's offered in another county and how do you communicate with the treatment coordinator in a patient's county of residence. I just maybe want some head nods that, let's say, our smaller populated counties. Is there a treatment coordinator in every county in Wyoming currently? And what happens if there is no treatment coordinator in one of those 5 or 6 smaller counties? They just find the nearest county that's willing to provide this answer?
Mr. Fuller?
Madam Chairman, Representative Swanitzer, the only thing I would note is under current law, the department in consultation with each board of county commissioners may establish a gatekeeper. So it's discretionary in terms of whether each county does or does not have a gatekeeper. I would have to defer to others.
The director of the Department of Health the interim director of the Department of Health has indicated the answer to that is no.
Madam Chairman, Representative Swanitzer, we have what are currently called gatekeepers, referred to here as treatment coordinators in most counties, but not all. And Mr. Fuller's right. The process outlined in statute now is that we consult with county commissioners to designate those. Generally, a community mental health center is in the interest of the department and I think the state to use that infrastructure because it's part of their mission. So the statute language today, because of that inability to always have them, says shall notify any designated gatekeeper. So just wanted to make that clarification.
Representative Provenza.
Thank you, Madam Chair. I just had a question on, so if you go back to the definition of treatment coordinator on page 11, means an entity designated by the department for a particular county to coordinate proceedings under this act. Is there reference to exactly like anywhere else in the bill that specifically says what that means? Because this language seems to me to be very broad and vague and doesn't have any parameters as to what a treatment coordinator is. So what do they have to know to be able to be a treatment coordinator? And their duties, are they employed staff, are they volunteers? So I think that definition concerns me if it isn't somewhere else tied to something more meaningful.
Mr. Beaver.
Madam Chairman, I think that language is the current. If you just change the word gatekeeper to treatment coordinator. So.
Mr. Fuller.
Madam Chairman, Representative Provenza, at least in this bill draft, I'm not sure there's, that express sentence that's currently in 2510-112G, where it says, the department may establish a gatekeeper. So I think the question would be whether some sentence should be included that either does or does not require the department or some other entity to establish or designate a treatment coordinator, as that term's used here.
All right, additional questions, committee? Representative Yen.
Madam Chair, just so I can clarify, so what we're saying is that right now, in current law, the counties designate a gatekeeper, usually a community mental health center. But in the current bill, there isn't really language that outlines what that process would be to choose a treatment coordinator.
I believe that's correct, Mr. Fuller.
Yeah, Madam Chairman, Representative Yen, yeah, the definition says, for treatment coordinator is, I think a person or entity designated by the department for a particular county to coordinate proceedings under this act. I think the gap maybe that Representative Provenza has identified is nothing says, that the department shall or may designate a treatment coordinator.
Representative Yen.
So Madam Chair, maybe a question for the Department of Health is, do they want this responsibility to designate or do they want to leave it back to the counties?
Director.
Madam Chairman, Representative Yen, we would undertake the same process, whether the shall language was established in this bill or it was just in definition. Probably better. I'm not a legislator or an attorney to establish that in statute, but I think that could be handled simply at a later time. But the designation would, as written in this bill, would largely operate similar to today.
All right, committee. Are we ready to go to page 33? I mean, it's good work, Mr. Page 33, that staff comment there. The committee may wish to consider whether there would be situations where a patient lacks the capacity to consent at an initial hearing, even though involuntary hospitalization may be most appropriate. So I do have that this starting on page 32 associated with the process is all new, and it really is the substance of the bill. So this is where we're really getting into the heart of everything right here. Despite all the work we've already done. We're just now getting into the heart, but that is good. So when we look at that, So I'm looking really on page 32, starting on lines 26 into the next page. It says that the court shall not order a patient to be placed in involuntary hospitalization at the initial hearing unless the patient and the patient's attorney consent. So a great question here is, a person is in crisis and clearly needs emergency services. Do they have the capacity to consent? And is this a legal question or is this a medical question? And I posit that it is a legal question, which is different than a medical question. And so this is where the Health and Labor Committee and Committee number 1 come in together. And this is why I wanted to focus just on the legal process and have the county attorneys work on this. So this is a legal question regarding consent capacity in a legal context. So Representative Zwanitzer.
So in a legal context, how quickly can a patient get an attorney? Can a judge appoint one right there after the 3-day? I mean, some of these hearings happen pretty quick. And so the patient is given an attorney whether or not they want one or even understand what's going on against them. And so I'm not sure if it should say or. I mean, the patient may not want an attorney against their own rights. I have difficulty with that sentence unless you have both a patient and a patient attorney consent. I want to make sure that means the same as agree. I don't understand legally how you get there.
Mr. Beaver?
Madam Chairman, this comes out of the existing statute, which provides that the court cannot order involuntary hospitalization. That there's what we call the 109 and 110 hearings, the 109 being the initial, the 110 being the involuntary hospitalization. It does provide that in the event that the patient waives the hearing, so we've got the term waive as well, it's equivalent to consenting for the court to go forward with the involuntary hospitalization. So that conceptually, this is what the current statute is. And our recommendation is to maintain that. It's what I would characterize as a conservative approach. To start out in the initial hearing and blast into an involuntary hospitalization is anything but conservative.
Senator Cooper.
Thank you, Madam Chair. I'm a little puzzled here by the language here. And we're in the right group. As much attention as you folks spend on may and shall or and or. Once a person gives his consent, how long is it any longer involuntary?
Mr. Beaver?
Madam Chairman, Senator, that's a very perceptive question. The courts seem to be very comfortable finding that patients are competent to consent to certain steps in the proceedings, like waiving a hearing or so forth, but that is not then equivalent to being a voluntary admittee, but very perceptive question.
Madam Chair,
Senator Kolb.
thank you. Page 33 in line 1, really. And the patient's attorney, if I understand this relationship correctly, the patient's attorney is supposed to be doing what the patient wants them to do. They're not an advocate for their general well-being, are they? I thought their job is to represent the patient's will. And so it would look like under this statement, this sentence, that if the patient didn't want to be involuntarily committed, they wouldn't be. And I don't know why the attorney in this case would argue contrary to what the patient's will was. So could someone help me with that? Thank you.
Good point, Senator Kolb and Mr. Beaver. I think that's important. Does the patient's attorney really need to consent or just the patient's consent? Mr. Beaver, your thoughts?
Madam Chairman, this is really inside baseball, but it's significant that the attorney be included in that consent because of their understanding of the procedure and the law. We of course think of them in terms of being an advocate as essentially just being a mouthpiece, but they are more than a mouthpiece for the patient. There may be considerations that of a legal nature that the attorney would say, I feel compelled to not consent, even though my patient is saying I consent.
And now you know how hard it is to be a lawyer. Representative Corrigo.
Madam Chairman, I think what Mr. Beaver said just pointed out why I had problems with the language regarding advocate versus representing the interest of the client, which aren't always the same. And I mean, he just pointed out why I told Representative Zwanitzer under my breath, I didn't really like that language. And I think this points out why, because we as lawyers have other duties sometimes that fall outside of just representing our client. There's a whole book about them.
Yes.
And we have to follow those. And I don't, whether we're representing a Title 25 patient or somebody else, I don't know. I have problems with us putting that in statute about what exactly those rules are, and it limits our abilities to follow our other rules. So I don't know if we go back and look at that. I understand what Mr. Beaver's saying, but those two provisions of what he just said and going back a little ways contradict each other. Just pointing that out. Thank you.
Representative Zwanitzer.
And so just tell me, I think I'm getting it now. If the patient truly becomes cognizant and says, I do need help, and their attorney, even if it's appointed, agrees, you can have a fast track to a facility, to the state hospital. If that patient is willing to go ahead and say, yes, I need this. But in almost all cases, I'm just guessing the patient is going to say, heck no, I don't want to go. And you're going to automatically trigger a further hearing, which I think is the intent of why this is here. I think there's got to be a better way to state it in the law than the wording we have, I guess is my concern. And apparently my colleague to my left has a great amendment to do that.
Hold on. Representative Provenza.
Thank you, Madam Chair. So I'm looking at the emergency detention, what I think might be the process in 2510-109. And some of my concern here is that it looks like we're going straight into an initial hearing with the patient and patient's attorney's consent without having notified like what we consider an examiner yet. And so while I appreciate the use of the attorney to someone else to help advocate for the patient, we don't have anyone involved yet in this process up to the hearing who can provide some sort of medical or psychological information that the patient might also need to take into consideration when they are consenting to this hearing. And then in 2510-109B, it says immediately after detaining the person, an officer shall contact an examiner. And if that preliminary examination is not conducted within 24 hours, that detained person shall be released. And so I guess I'm just concerned that am I missing something here? That is there someone else involved advocating? Is there a psychological something or other advocate involved before we get to this process so that they can?
Mr. Beaver.
Madam Chairman, yeah. I know we're on 601, which is the very first section talking about process, and it's sort of an overview of how the various elements, emergency custody, involuntary hospitalization, and directed outpatient, how they mesh. There is a lot more detail to come as we work through the rest of the bill. But the short answer is yes, the examiner is engaged right from the get-go. And so there is information available to the patient's attorney, to everybody involved. I think that's what you were asking.
All right. Thank you. I have Senator Cooper.
Thank you, Madam Chair. I'm still puzzled on the wording here. And I'm sure that there's a right way to do this, but once we consent, then we're voluntary inpatient. It's not worded right, is my point. And I'm not sure where we go with it.
Senator Cooper's plain language interpretation of what this says indicates that if a patient consents, they are no longer involuntarily hospitalized or emergency detained, but rather they are voluntarily admitted. Would someone like to address that more squarely for the plain language reader of the statute? Mr. Beaver?
Again, I just have to say that within the judiciary, the consenting to a step in the judicial process is not a equivalent. It'd be like in a criminal trial, if a defendant didn't object to a piece of evidence in the trial, he's not confessing to murder. Those are just two different elements.
Representative Oakley?
Thank you, Madam Chair. I'm just going to reiterate, I guess, what Mr. Beaver said. So it's just consenting to say, I don't need to have that hearing. It doesn't have to have any factual bearing on what his mental or medical state is. It's just a consent to waive a hearing. That's it.
Representative Craig.
Madam Chairman, so I would like to make a motion
Oops.
to amend the language to solve this little conundrum.
That'd be wonderful, Representative Craig.
So page 33, after the word patient, I would strike and patient's attorney consent and insert the following language, which is waives the hearing provisions of 2510-604.
Second? Seconded by Representative Swanitzer. Further discussion on the amendment? Mr. Beaver, any comments?
Madam Chairman, that sounds good to me.
All those in favor say aye.
Aye.
All right, any opposed? Thank you, Representative Krager. All right. Let's move to page 34. All right, this deals with who can transfer. I'm not sure, is subsection D necessary? Thoughts from the committee? Representative Yen?
Madam Chair, I'll make a motion. I don't think it is necessary, but I think it's good to have it just so it's clear in the process. But I would move to strike on line 2, everything after this act, and strike the whole of line 3 as well. So it would read, a peace officer may transport patients subject to this act, and remove the policy language.
Okay. Moved by Representative Yen, seconded by Senator Cost. Representative Washit.
Thank you, Madam Chair. I seem to remember talking to representatives from law enforcement who participated in some of the early discussions about this bill, that this was language that they supported for the purpose of recognizing that different agencies had different policies with regards to transportation beyond county lines, what types of vehicles would be involved in transportations and so forth. And so I think we should keep this language in. If it really needs to come out, maybe we can deal with that at the at the budget session.
Representative Oakley.
Thank you, Madam Chair. I agree with Representative Washit. So I think law enforcement specifically wanted this both, of course, the May transport, as well as in accordance with their policy, because they're concerned about, I think, about any sort of, like it becoming, they don't want it to be too broad, that this becomes their responsibility. So not only May, but also if they don't have a policy that they can do it, that it doesn't become a requirement for law enforcement. They're trying to, I think, maybe do what they can to limit their exposure and entanglement in this situation.
Representative Washit.
Thank you, Madam Chairman. And I think it goes beyond that. I think that one of their concerns dealt with restraint. And there was a concern that what the Department of Health might think would be appropriate levels of restraint and so forth of someone they're being transported might be contrary to their department's policy on restraint of an individual that the officer felt was dangerous and so forth. And so they wanted to be in control of that policy decision on restraint of the person during transport and not have the Department of Health set that policy for them.
I think you're right, Representative Washit. Representative Yen.
Madam Chair, so then I think if the situation where the transportation policy of the Peace Officers Agency conflicts with the Department of Health rules on transportation, the agency just can't transport that individual then, right? So I think the May language is fine. I think the in accordance language, I made the motion to get rid of it because I think it's unnecessary. I think already with the May language, they still can either do it in accordance with their policy or not. I just think it's superfluous language that's unnecessary in the bill, but it's up to the committee.
So chime in on this discussion. I think both representatives are correct. So I actually believe if you read it, Representative Yen is right. I do think it appears to be superfluous, except in the concept of very complex civil litigation, which deals with restraint, which is a highly litigated area, which causes law enforcement agencies grave concern, because how law enforcement chooses to restrain somebody in one of their vehicles is likely very different than how a hospital may choose to transport somebody either in an ambulance or in a helicopter or some other automobile. And how a patient who is in a state of crisis may harm themselves under those circumstances is different. And so I think that's the concern. And at first blush, I agree with you that language is superfluous, but I also think if we're going to invite law enforcement into these circumstances where we're transporting patients, where clearly society doesn't think law enforcement is fit to deal with people in states of mental crisis, then they would probably want that protection associated with their policies. If you're going to have law enforcement transport, then law enforcement's training and policies should be the ones that apply. I think that's the grave concern there from both parties. Further discussion? Senator Cost?
Thank you, Madam Chair. So because the health department is going to promulgate rules for transportation, what if we just remove the peace officers from it and see what the health department chooses and leave it to them? And then if something else is entered in, then further action can take place. But I'm just saying, why do we bring it in if the health department is going to promulgate rules for transportation of the patients? Maybe this is not necessary.
Representative Oakley.
Thank you, Madam Chair. I guess I'd just like to point to the comment by the county attorneys. I think they're right, and I don't think any change needs made. The Department of Health their rules on transportation and law enforcement, depending on which it is. Both standards or either standard, depending on the situation, would have to be met. It allows for flexibility of all the different types of situations. I don't think we need to do a fix here. Thank you.
Sensing you're ready for the question. All those in favor, please say aye. All those opposed, say no.
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 That motion has failed. All right, committee, down to the second staff comment on 34. So we're looking at page 34, lines 17 through 19. No person or entity shall be liable for injury to a patient that occurs while transporting a patient by reasonable means for purposes of this act. Representative Swanitzer. Representative Craigo.
Madam Chairman, question for Mr. Fuller. Does this take us outside the scope of the Governmental Claims Act? We saying we're not subject to the Governmental Claims Act anymore, or do we need to clarify that?
Representative Craigo, my thought is this applies to both private entities as that may apply to also public entities, but it doesn't necessarily directly hinge upon the Governmental Claims Act. But I think no one is liable for injuries to a patient. I'm surprised the trial lawyers left. They stayed for the AAAE case. But this one seems to be a profound liability protection associated with the injury to patients being transported, which is a high area of risk, right? For anybody who is participating in the transport of a patient, whether it be law enforcement or otherwise. So we are providing carte blanche immunity so long as reasonable means are being applied. Representative Swanitzer?
And I guess my concern, how I read it, when it says transport, that's both from a facility, let's say in an ambulance, but that's also wheeling someone down the hall, the way I read it, when inside of a facility. The whole section gives me pause. It's like a blanket immunity, and that kind of worries me, but I don't know how to fix it today.
Representative Washut, and then we'll go to Senator Kolb.
Thank you, Madam Chair. I think we also heard testimony about patients being returned home after treatment, and that some of those were going by bus, maybe even taxi. And so I'm sure this immunity provision extends far beyond what we were perhaps contemplating, maybe even the wheelchair.
Senator Kolb.
Thank you, Madam Chair. I think what really needs, I'd like to point out that, this is a highly dangerous situation in many cases. And we in Sweetwater County, I can explain that they do use private transport, the ambulance service, to transport these patients to WBI or wherever it may be their destination. But we need to realize that this is really an imperfect world, and I think this is necessary so we can get interagency cooperation for the purposes of helping these folks and helping society. And I know it's not perfect, but I think it's what's needed to be done. Thank you for my chance to comment.
Thank you, Senator Kolb. I also think there's there's the policy question behind it, which we're discussing. And then there is, I think, a technical correction to change the word injury as found on line 17 to damages. Is a potentially technical amendment. So damages would be broader, I think, than just injury, and damages is something that is a term of art in the legal profession associated with any harm. Is how one is damaged as opposed to injured. Good discussion. Senator Cooper.
I'm thinking. There's a little stuff going on in here. I'm hearing voices. So in the process of transporting this patient, the ambulance or maybe the sheriff's vehicle or whoever it may be, misses a corner and drives out through my fence. Who pays for my fence?
I think the language indicates that it's to a patient. So they still have to pay for your fence. Maybe a cow,
What if he's the patient?
maybe a couple cows.
What if he's the patient?
But the patient, but the patient, if injured while crashing through the fence, has no recovery, but you do for your fence. Okay. I know, I know. Policy of provide, I'll say, so Senator Kolb has provided his thoughts that he believes providing this immunity protection is important in order to encourage interagency cooperation and to kind of facilitate the transportation of these high-risk patients. Does anyone else feel differently? Are these, so let me take the argument from the trial lawyer's perspective, since they're not here. Are these patients highly vulnerable? Is it easy to treat them poorly? They're a pain, right? They're not following orders. You throw them in the back and you drive recklessly and they get hurt. Who should be responsible for that? Right? They have no recourse. You can be as terrible as you want. Minus intentional acts that would be considered criminal, but you can be as negligent as one would need to be. I don't know what that means. Representative Craigo?
Madam Chairman, I have the same concern you do. I don't know what reasonable means. I don't know what it's an adjective. What does it apply to? I mean, within that clause, what is the reasonable means we're talking about? Is that your mode of driving? Is that your mode of securing the patient within the ambulance / cop car? I mean, I just think that language, I know what we're trying to get at. We're trying to get at some like negligence versus gross negligence standard, which I'm okay with if we could get to that sort of language, but I'm not, this essentially is blanket immunity, no matter how bad the transporter acts. And I don't know if that's a great public policy statement for us to make. I'd rather, I mean, we still should be held to some sort of standard. I don't know what it is, not professing to know. But I agree with you in your comments.
So a couple of suggestions that I have, Mr. Beaver or others, is to, if you want the policy of providing some liability protections for the transportation of these patients, then maybe we can word something a little bit more better, a little more better. And I think that that's necessary for this provision to survive. So we can either keep it in for now, recognizing we're going to come back, or we can remove it now and add it back later. So whatever the committee chooses to decide, do you want to keep it in right now or keep it in? All right, so let's move on. Does anyone want to do the damages? No, we'll just wait. We'll just wait. All right. All right, so let's go to page 35. We're considering the breadth of this bill.
Madam Chair.
Representative Provenza.
I'm sorry, I had my hand up for the last one. I have a quick question for Mr. Fuller. Sorry to take us back to E, but I don't want to leave it the way it is. Is there in other statutes already this like something in place that would protect the entities that would be transporting these people as long as they're acting in good faith and not being maybe engaging in misconduct? Is this that's my first.
Mr. Fuller?
Madam Chairman, Representative Provenza, at least for the public entities, I think the Governmental Claims Act would apply to them. In terms of private entities, I'd have to take a quick look, but I'm unaware off the top of my head of anything, certainly to this breadth of the immunity that's provided in the bill draft.
Thank you, Mr. Fuller. Further questions?
Madam Chair.
Representative Provenza?
I would like to motion to strike line 17 through 19 on page 34 And if I can get a second.
Seconded by Representative Yen. Further discussion? Seeing none, question being called. All those in favor, please say aye. All those, all those opposed, please say no.
No.
It was a fun exercise. Thank you for bringing us together, Representative Provenza.
Just
All
want to
right.
make sure we're all awake. It's dark now.
All right, all right. All right, let's go to the breadth of subparagraph H on page 35, lines 12 through 13. So the court shall hold an expedited hearing on any motion filed by any party under this act. Mr. Beaver.
Madam Chairman, I did a little research this morning and called our district court scheduler. The term expedited hearing does appear in other places in statute. So I had an opportunity to ask her, what does that mean to the court? And she explained that unless there's an actual deadline, which of course the court honors, it's just received as kind of a suggestion to prioritize these hearings. But, you know, because we're on such short deadlines, I've certainly never felt that the court was putting off any hearing under Title 25. So basically, it's just sort of a policy statement to the courts that the legislature considers this a priority on their docket.
But we like telling other branches of government what to do we not? I mean, Mr. Beaver, I see your point, and I, even though there's a shall, it's kind of an ambiguous shall about when anything is to occur, but recognizing the significance of the Title 25 emergency detention process, which really does interfere with somebody's civil rights in a pretty significant way. And this is consistent with that policy of ensuring that things are handled as urgently as they should be. So any amendments on this, Representative? No.
Yeah.
Senator Cooper?
Thank you, Madam Chair. I'm just wondering if that 72-hour number shouldn't pop back up here again, related to the urgency of this matter.
Representative Wanitzer?
Madam Chairman, my amendment or my motion would be to remove all of section H, lines 12 and 13 on page 35.
Moved by Representative Wanitzer, seconded by Representative Yen. Discussion, you know, a couple of things. For those who would be concerned about civil rights and individual liberties, the need to have an expedited hearing is fundamental to that. Someone is being detained against their will, right? And courts do understand that. And I believe that our judges and our district courts will try to have those hearings as quickly as they can. But it is not atypical, particularly in these areas where we need to add additional judges, that they are unable to have hearings on whatever motion might be filed. And sometimes in some of these very important cases, these linger for an extensive period of time. And judges are up for retention. And this is one of those policy considerations that a judge could be measured against for retention for failing to conduct expedited hearings for these types of cases or where an individual's civil liberties may be at stake. So I do think that there is some pretty fundamental concepts here, even though in practice, it seems silly. The overarching policy is pretty profound and has some utility. I'm gonna keep it. I think it's important for it to stay. You know, so for in our juvenile actions where parents' terminal rights are at stake or other issues, there are very specific deadlines for when things have to take place. In our criminal cases as well, you have to come before the court within a very particular period of time. You have an Eighth Amendment right to a speedy trial. We don't have deadlines necessarily here in our Title 25 actions, but somebody's civil liberties are still as equally at stake as somebody who is charged with a crime and in custody, like a jail. So I think this is a safe way to keep those, you know, very important policy considerations in place without putting an undue burden on the courts with a very specific time frame. I'm voting no. And that was my speech. Thanks for bearing with me. Further discussion? Question being called. All those in favor, please say aye. All those opposed say no.
No. No.
All right, that motion has failed. Page 36, we're kind of back to this understanding of whether or not a patient lacks capacity to waive a hearing. You know, it's my thought that we don't need to address this, that the court process already does this automatically for any person who appears before the court, that an attorney and the judge is always constantly evaluating whether or not that person has capacity. And so I believe the oath and as officers of the court, the lawyer for the patient has the ability to determine whether or not their client can actually waive the hearing. Senator Costa agrees with me. All right. Any further discussion on this piece? Moving on to page 37. On to 38. Let's go ahead and look at our county attorney's comments on this. County attorneys say disregard. Any further discussion here, committee? Representative Washit?
You know, if we need any language at all, it seems to me we should set it up as a default situation that when you have a situation where the legal justification for hospitalization no longer exists, then the default is release. And if the prosecutor or the county attorney remains silent, then the default kicks in.
Further discussion? I can see people working, letting you have that time to work. Representative Provenza? Your background is light and it's sometimes hard to see that yellow hand. That's why sometimes I miss it. Representative Provenza, go ahead.
Thank you, Madam Chair. Yeah, I guess my concern is it just seems problematic to me that we're gonna keep folks in for 3 days. I mean, I understand that the county attorney can turn around and say immediately that they don't object. But as we heard earlier, there's a lot of burden on work and tasks and things that the county attorney has to do. And so I'd hate to have someone sit in detention, in some sort of detention, and not be able to leave because they're waiting for county attorney who is just overworked and underpaid.
Further discussion from the committee? Further actions from the committee? If not, we'll move on. Are you ready to move on? Okay. Going on to page 40. And are you ready to move on because you're tired and it's 5 o'clock? Oh. All right, page 40. Reference to treatment should be included in the subsection above.
So, Madam Chairman, it does seem that treatment has to be a necessary component, I would assume, of being held. Otherwise, you're just voluntarily agreeing to stay somewhere. But if you refuse to be treated, I understand the reason for the staff comment and do believe there has to be a component of improvement, treatment, something more than just remaining and consenting to remaining. That's a prison. That's not a treatment center or hospital that's, charged with providing care.
Representative Craigo.
Madam Chairman, I guess question maybe for Mr. Fuller. Is this language redundant based on some of the amendments we've already made earlier in the bill?
Put it out to the ether. Further discussion from the committee? Yeah, so Senator Cost is referring to the county attorney's comment on page 40. County attorneys say that the staff comment notes a possible situation where a patient is already in a facility and is not threatening to leave the facility but refuses to accept treatment. We recommend adding a subparagraph C, Romanet 3, that says accept prescribed treatment. So no person, so it would read no person with a serious mental illness, which we no longer have. No person with a mental illness shall be placed in emergency custody under this section unless the person will not voluntarily accept prescribed treatment. Is how that would read.
So move.
Moved by Representative Washut and seconded by Senator Cost. Discussion from the committee? All those in favor, please say aye.
Aye.
Any opposed? That motion has passed. Okay, going on to page 41. I'd encourage the body to look at the county attorney's comments here. All right, moving on to page 44. County attorneys do not recommend doing anything here if you look at their comments. Representative Craigo.
Sorry, Madam Chairman, can we go back to page 43 and I'd have on line 19, I would move to have the same amendment we made previously regarding file a petition in the interest of.
Entitled.
Entitled in the interest of.
Yeah, and Mr. Fuller, that previous amendment, can we make that conforming throughout? Make sure we capture that. Yeah. Okay. Good catch. All right, so page 45. So the county attorneys do agree with having the evaluation report submitted to the court. So it looks like there's some action items here very clearly. Representative Monitor?
Thanks, Madam Chairman. I guess my question is it just an assumption that the county is going to want the patient discharged as soon as possible? When we're talking about who gets the report, obviously the court's making the decision. We probably want the court to be aware instead of, and I guess because the patient's attorney is in many cases would be appointed by the court. I'm trying to figure out whose interest is at stake and who's most likely to try to get that person off an involuntary commitment as quick as possible. I do think the court probably needs to be notified only because the county attorney, the patient's attorney may actually be appointed by the judge. And could it be a county attorney? Someone who's employed by the county attorney's office? It's going to be a private attorney. I just want to make sure in some of these small towns and cases where there's not a lot of attorneys and there may not be a treatment coordinator. I think I need one more person who gets the report and probably just the court. So I do like the idea that we would submit the evaluation report to the court as well. I just don't know. Well, so I guess my motion would be to add the word court after county attorney on line 11. And I know that was a long stumbling soliloquy, but I would ask for a second to add court after county attorney on line 11.
Seconded by Craig. Representative Washit, discussion?
I would suggest maybe a friendly amendment if the bringer is willing to also include law enforcement here. In some of these circumstances, we have criminal acts that have preceded the involuntary committal. And if we don't notify law enforcement before we release the individual, it may make it more problematic for law enforcement to locate the individual and for purposes of criminal prosecution. So I don't think it would delay much if law enforcement were put on the contact list.
Madam Chairman, I would probably say it's not friendly only because in my other life, I think that's a HIPAA violation. Yeah.
So the sponsor does not find that friendly of the amendment. So we're still on the amendment, which is the addition of the court. Further discussion on the motion? All those in favor, please say aye.
Aye.
Any opposed? All right. Any further actions here on page 45? There should be a process specified in statute for a patient to seek termination of a continued emergency custody. Staff comment? And the county attorneys do say that there is a process in the bill draft at page 35, line 5, as Senator Cost has identified. So go back to page 35, line 5. That serious mental illness term again. Representative
I
Wanitzer?
guess I have a question how this works in practice, because from what I hear from everyone, we have a lot of continued patients who come into the system, they go out of the system, and then they're back in 3 months, 6 months, 1 month, 1 week. And so if we have a situation, which I think, there's substance abuse issues, there's all sorts of things that trigger this. They're in containment, they get better. Sure, they say, the evaluation says, hey, they're back to good again. And then, so you release them and a week later, they're back. So I have to think in some instances, even though the evaluation report would say, hey, they're back to baseline based on 3 years of data and seeing this person 9 times, it's not our recommendation that even though the examiner says everything's good, but I would imagine maybe the court or a treatment coordinator or the county attorney would say, yeah, this time we think we need some more serious intervention, and even though they're back to okay, we're not going to recommend release. Does that happen, or are we just stuck releasing and going through the cycle over and over without a more prescriptive means of really helping someone holistically long-term?
And my understanding is no, the courts do not go into that space of determining what would be a holistic approach for the care of that patient. Going back to the concept of an involuntary hospitalization, I mean, how would you feel if you were involuntarily hospitalized, right, without an ability to leave? It is a significant and profound violation of someone's individual liberties, right? And so even if we think they're not necessarily well and that they should stay hospitalized or continue to receive significant treatment, the court is not willing to step in anyone else's shoes and to continue going into the space of their individual liberties and have them be involuntarily hospitalized for any longer than necessary. Mr. Fuller, do you want to comment further?
Yeah, Madam Chairman, not necessarily on that. I just wanted to answer maybe my own staff comment. In terms of the patient should be released, I think the language that begins on page 36, line 23 would provide, except for the first 72 hours, if an examiner determines, I think that language is broad enough to cover this scenario as well during continued emergency custody.
So you think that the bill draft does cover that concern? Okay.
Madam Chairman, I believe it would.
All right, moving on to page 46. We're getting close. So I think we heard testimony yesterday that from Ms. Somerville that WAMSAC agrees that the committee may wish to consider whether an examiner and not just a physician can give testimony. The county attorneys point us to 2510-110E on this topic that says the current statute requires examination testimony of a licensed physician, licensed psychiatrist, or a licensed psychologist. If an examiner does not hold one of these three licenses, the court must appoint one to review the findings of the examiner and to report it to the court. The bill draft was intended to preserve that level of expertise. And so I guess Mr. Beaver is recognizing that somewhat of a policy question there, maybe you didn't want to do. Is this working? Do you think that that's the requisite level of expertise necessary, or should this be changed?
Madam Chairman, I can only speak to my experience representing folks in Sheridan County. We have the VA facility here that has psychiatrists on staff, so it's not an issue for them. We transfer most of our inpatient folks to WBI. They have psychiatrists on staff, so it's not an issue there. I can't speak to the counties that you've heard concern from where they may not have a licensed physician in the county, period. I can't speak to them.
Any actions from the committee on this concern to add examiner and not just physician? Seeing none. And then going on to that first staff comment about whether it is possible that an evaluation report is submitted within 3 days. And I'm assuming since the county attorneys put this there, that they believe it is possible. Is that fair, Mr. Beaver?
Madam Chairman, it's in there because of the concern that if there isn't something pushing on the very busy treatment provider to get a report out, we would get a report 30 seconds before the hearing convenes. And that's just not a good situation for anybody. 3 days was sort of an arbitrary number to throw out there. I think whatever lead that the legislature is comfortable with, we'll all work with. Obviously, for the providers, they would probably like the least amount of advanced requirement, and for everybody else, we'd like the greatest amount of advanced notice.
All right, thank you, Mr. Beaver. Committee ready to move on?
Madam Chair,
Representative Yin?
may I go back just one section just for a second? Department of Health mentioned in their notes that the period for a continued emergency custody, which is on page 44, line 28, is now 21 days, which is longer than an existing statute, which was 10 days. And that they noted that it could raise civil rights concerns. So maybe it's a question for both the prosecutor on why the length of time is longer and if there are other concerns from the Department of Health on that time period.
Mr. Beaver?
Thank you, Madam Chairman. Yeah, I'd like to explain the 21 days. Currently, we have the 10-day continued emergency detention. That is very frequently followed by an additional 10 days. So we're at 20 days now as a matter of practice. The idea would be that by setting it up for 21 days without a hard requirement for a hearing, you save the judges and everybody's time for that intermediate hearing. To counterbalance that, though, we have introduced a requirement of a 7-day evaluation built in. So you'd actually have a quicker than what the current deadlines are as far as getting information out to the parties with regard to the current condition of the patient. So it's a countervailing approach with those two provisions combining to what we feel would be just more efficient judicially. It's very wasteful of everyone's time when the psychiatrist and the judge and all the attorneys are sitting there and going, yeah, same as 10 days ago, but we've got to schedule this and take up the court's time to do it. We're just trying to make some efficiencies there.
Representative Yin?
Madam Chair, if I may just ask the interim director if he had any other concerns.
Dr. Johansson?
Madam Chairman, Representative Yin, I certainly don't disagree with Mr. Beaver. And I think it was last year we talked through that and sometimes the need to, with that 10-day continued hold, to just have another day or two with the patient so that they wouldn't require a hospitalization order. We understand that. I think from, again, it's not always our place to bring this to the committee's attention, but there are lawsuits that arise that everyone, I'm sure, is aware of in states that have overly restrictive civil commitment laws. And I think timing is a big part of that. While the intent and the judicial efficiency, I can certainly see that. Not everything works in every county the same way. And I think the ability to hold someone for that duration could generate some legal issues, or at least some patient civil rights issues. But again, totally understand the intent. It just is a significant departure from current statute and what we typically see in other state statutes, which for some reason, it seems like everybody copied each other. You typically see the 24-hour initial hold followed by a 10-day extension, followed by a required hearing for a disposition.
Mr. Fuller, questions for LSO or follow-up for later is any legal concerns associated with extending it to 21 days, and if any courts have found that to be excessive, and who they faulted if it was in statute, how that worked. Any comments about that, Mr. Fuller?
Not today, Madam Chairman, but I can look into that.
Yeah, we'll go ahead and do that. Any additional comments here?
Madam Chair, I'm not going to make any motion at this time, but I think having that memo for whenever we talk about this on Zoom will be very helpful. Thank you, Madam Chair.
All right, going back to, or going forward to page 48. This is the staff comment there. The committee may wish to consider clarifying who, if anyone, is required to submit the directed outpatient treatment report. The county attorneys recommend the treatment coordinator. Can I get a motion on that? Looks like we've got some thumbs up. Moved by Senator Cost. Is there a second? Seconded by Crago. All those in favor, please say aye.
Aye.
Any opposed? That motion has passed. Okay, moving on to page 50. We'll go ahead and take a minute and just read that ourselves quietly.
Can I have a question, Madam Chairman? So
Representative
under the
Swanner.
Child Protection Act, would it take expedited? So if they commit my minor for being, let's say, suicidal hypothetically, against my will and refuse and involuntarily commit him against my will, and I don't consent to that treatment, and I do file a motion under the Child Protection Act, does a court view that as an expedited the same way they would any other Title 25 involuntary commitment? I'm not sure they would, is my concern. And so I feel like moving it to Title 14 is not, and this hits close to home for me. I mean, as some of you know, so it was not a good situation, and I got my kid out in a day, and I did not think he was at all suicidal, but he did get involuntarily committed against my will when I tried to remove him from the facility. They told me I couldn't do that, and it took a day to get him out, and I had to have 2 psychiatrists sign off. But I do think parents, especially children, you know, it's difficult when a doctor says one thing and both parents are on the same page saying, we don't think so. We know this kid really, really well. And I do believe there's still a parental right that should hopefully supersede a medical professional when it comes to my kids. So I'm not sure how to put that in statute, but I don't think moving into Title 14 is the correct place. I'm just not sure how to give parents more discretion. They're on page 49, lines 20 through 23 at this time. But if we continue this bill, I guess I would like LSO to consider some language for a better procedure than just moving under the Child Protection Act on how to expedite a process when it's parents against a healthcare provider.
Mr. Beaver, I am completely unfamiliar with this scenario. Can you speak to how that works currently for children who might need to be taken into emergency custody and their parent or guardian does not consent?
Madam Chairman, unfortunately, my expertise has been exceeded at this point. Ms. Reed is much more experienced. Well, I have 0 experience with juvenile law, so I don't know if she's available or not, but I'm afraid I can't weigh in.
Looks like Mr. Fuller is on the ready as usual. Yeah.
Madam Chairman, Representative Swanser. First, I guess to address the question about, the expedited proceedings, under current law, it just says, a petition may be filed under the Child Protection Act. I would assume at that point, the provisions of that act and the process for adjudicating a neglect petition would follow as those provisions exist in Title 14. Under current law, this is 25-10-109F. The parent or guardian of a minor may consent to treatment. If they do not consent, then a petition may be filed, and then treatment may be given without the consent of the detained person or his parent or guardian when treatment is limited to diagnosis or evaluation, or when treatment is necessary to prevent immediate and serious physical harm to the person or others. So that is what current law reads regarding the treatment of minors, at least without consent.
Representatives Wanetzer.
So in my experience, treatment at that point, they wouldn't even let my kid read a book because they said that was, possible treatment option for him. And so they literally, put him in a room for 8 hours because we had our child say, that he and his parents did not consent to treatment. And they just kind of held him and didn't give him access to really anything, because anything could be considered a treatment option within the law that they understood it. So again, I don't know how to emphasize a more parental rights role, but if there's an expedited hearing, I guess I can work with LSO on an amendment, because I do think, there's a lot of worry, especially when it comes to like suicidal behavior in teenagers, especially where a lot of these, I think, come into play. The kid may say one thing, but teenagers say a lot of interesting things and they change their mind 5 minutes later. So I don't have any amendments at this time, Madam Chairman, but I would ask LSO as this bill continues to think about where we could increase in parental rights in this area of law.
All right. Thank you, Representative Wanetzer. So you are going to work with LSO to do an amendment? All right. Any further discussion on this topic on page 50? Staff comment? Is everybody still with us? So this conversation concerning minors continues here. Pretty significant, probably a little late in the evening to be dealing with this topic, but we'll push through it anyway, because we're here. Further comments, page 51, 52? All right, looking at the comment on page 52 regarding which county attorney. What does county attorney say? Mr. Beaver, you did not get that far in your comments, or maybe?
Well, Madam Chairman, that's a pretty easy one for me. The contemplation would be the attorney in the county where the emergency detention is taking place. So some language to clarify that would be good.
So would that be on page 52, line 10?
Yes.
That's right. The circumstances to the Department of Family Services and to the county attorney for that county where the emergency detention has occurred, is occurring?
Emergency custody, yes.
Emergency custody. Representative Prego?
Madam Chairman, I'm confused. Are we talking about the place of the facility or the county where the emergency custody petition was filed?
Mr. Beaver?
Well, that's a good question, because you got to unpack that. Where it was filed, which should be where they were put into emergency custody, but could well be in a very different county than where the facility is. But once we file a case, the fact that the patient is transferred to a facility in another county that doesn't change the responsibility of the original county attorney involved.
Madam Chairman,
Representative Wanetzer?
which county is paying for the involuntary commitment? So in my case, my kid was involuntary committed in one county, was transported against my will to another county, and neither county attorney's office had the paperwork for 2 days. And both county attorneys helped me, but they just said paperwork didn't get to them. And so actually Miss Reed was amazing in my case, but she never did get the paperwork, even though my kid was, yeah, it was a really weird area when a minor gets transported against their will. But I would assume the county that's footing the bill, ultimately the one that should be notified and should be aware of what's going on, not necessarily the county in the middle of the state where a lot of the, especially for minors, would be transported to.
So would the amendment be, Representative Corrigo, that on page 10, page 52, line 10, the county attorney for the county where the petition originated? Representative Washit?
How about both?
We're compromising at 5:30 in many ways. Representative Corrigo?
Madam Chairman, I don't think we want to do both because that creates an obligation for that other county attorney's office to, they'll have pleadings coming in and they got to open a file on a case they know nothing about, and it really doesn't pertain to them or to any of their constituents. I mean, for instance, for us, let's say we title somebody in Johnson County, they end up going to the facility in the middle of the state in your hometown. Your county attorney would know nothing about the case, nor do they want to. It just creates an extra, I guess, extra work that doesn't need to take place, or that's how I view it. I think what Mr. Beaver is saying is, in that circumstance, it should go to the county attorney in Johnson County. If they started the emergency custody, they're the ones who should receive the notice, but I could be wrong.
Representative Washit?
All a little foggy at 5:30, but I thought we heard testimony that when patients were transported to my county, that the county attorney in my county was handling some of those pleadings in the court. And so it would seem to me that both county attorneys, the county where the emergency custody occurred and the county that is handling the legal developments in the case, would both be well served to be kept in the know.
Mr. Beaver? You have any idea?
Representative Washit does recognize the often the relationship between the Natrona County Attorney's Office for folks that are transported to a Casper facility, but that's not universal. I continue to handle all the Sheridan people, even though they're now in Casper. So that's a county by county difference.
So is it best that we leave it ambiguous? That was funny.
So Madam Chairman, I guess my question, is this because it's of a cost to a county, or is this because of the continuing legal procedure that may have to happen to keep that minor in custody long-term? Because those legal proceedings for continued, it's my understanding that takes place in the county where the minor now is, after the, original cost borne by the county for that 72-hour commitment. I guess once that's satisfied, what's the intent? Is it to notify that they're on the hook for the money? Its intent is to notify that this minor may be in a very long-term situation in a legal proceeding in a county that has no idea they've even shown up over the weekend. Though I know in the Natrona County case, they check every Monday and they get reports.
Director Schmidt, do you have any guidance on this? This is where you wanted to be on your Friday night. Thank you.
Thank you, Madam Chairwoman. Representative Sponsor, kind of getting to how I read this, I would suggest that the petition would be filed in the county of where the family lives, because it brings in the Department of Family Services here. And what I suspect is going to happen is that the parents didn't come to the facility. So there may be protective custody taken under abuse or neglect, which is going to have to be investigated locally. So then that petition, then if there is a court petition under a juvenile court case, would have to happen in that county. And this is kind of an interesting perspective because we do deal with this sometimes in In cases where they're severely mentally ill, serious emotionally disturbed children placed at PRTFs, where parents do not want to have them come home. And then we have to get involved from a neglect standpoint. So again, having that kind of in the county of residence would be valuable.
So ultimately, Madam Chairman, Director Schmidt, it's about the investigation that the county and that county DFS level office would have to initiate if the parents are not readily available to be found. So ultimately, it's about the child's last known address of family members, because this is not really about financials or even the continuation of the mental state of the kid. It's about whether or not the parent should be charged or investigated for neglect and abuse.
Abandonment.
Yeah, so Representative Zwolitzer, Director Schmidt, I think you're correct. And when we take a minute and just read that full paragraph, I think that to the county attorney, where the minor resides and where the minor's parents reside, the county attorney. So there's going to be 2 county attorneys potentially notified. That's fundamental here. One where the parents reside, and then secondly, where the minor is currently located. Is that your thoughts, Director Schmidt?
Madam Chairwoman, I guess what I'm thinking of is where the child resides, the county of where the child resides, because that's where the investigation will take place, not necessarily where custody happened or where they eventually ended up. But how I read this is that nobody can get a hold of the parents.
Right.
And so at some point, if the department is called, we're going to start locally trying to find those parents. And if we cannot find a parent, we're going to look for kin. So it's more in that situation where the child is living, which you would assume hopefully would be where the parents are living as well. But a petition, if we get to a place where there has been abandonment or there is neglect, where you have parents who just aren't showing up, then the petition will have to be filed, I would assume, and this is getting out of my legal expertise, in the county of where the parents reside.
Representative Washit?
I think this is further evidence for my suggestion of both, but I also think it's a possibility that
Sure.
I also think there's a possibility that there could be even a third, a young person from one county goes to another county for a party, something occurs, child goes into emergency custody in that county, is transported to my county to the facility there. So then you've got the county where the custody occurred, the county where the family resides, and the county where the treatment facility is, where the child is resident at that moment. So it seems to me we should err on the side of more notification rather than less if there's any ambiguity about who needs to be in the know.
Representative Craigo?
Madam Chairman, I think holy cow, we're getting into some weeds here. And I think I understand what the director is saying, but what I also know is DFS notifies their local county attorneys. So if DFS receives this report and it needs to go to a different county attorney, they will get it to that person. And that if there's a petition for neglect or abuse, that's a different issue than what we're dealing with here. And I mean, what we're gonna end up with an issue here. The reason I'm trying to hone in on which county attorney actually gets it and try to limit it to one is we get into a position where one county decides to, and we're gonna get to talk about this here in a little bit, but where one county titles somebody and that person resides in a different county but gets titled in a different county, who's responsible for that cost? And we're gonna argue about that language probably here in a little bit. And this is starting to get into that. And so I don't know the answer. I'm just throwing that out there as we think about that. Is the county that actually titles the person is the one that needs to receive the notice. They're the one handling the proceeding at that point. I mean, like in our situation for our county, the county, Natrona County actually handles all of the title work, as they do with a lot of the smaller counties. We contract with them and they actually handle all the paperwork, the the title is actually done in the Trona County District Court rather than our district court. And so it's a different situation there, but I don't know the answer, but I think we need to hone in on the county attorney that actually does the title work. They're the ones that need the notice for court purposes. We start worrying about the DFS stuff. DFS will notify whatever county attorney they need to for purposes of abuse and neglect or some other type of petition.
Is this a placeholder for us to come back to? I think that this can be resolved, I think with a little bit more information, both from DFS and from County Attorneys Association on this piece, particularly dealing with minors whose parents can't be located. Right, so this is a very narrow circumstance of a child who needs emergency detention, psychiatric care, and their parents can't be notified. So we'll probably need to hear from those county attorneys who've seen this more often for what makes sense here, and we can get this solved quickly, I think, with their expertise on the ground. So let's move on for now, committee. I know that we'll have to come back to that, but that's also an easy fix in session too, if it gets that far. So on page 53.
And
Director Schmidt, I think it's helpful here. And Mr. Fuller, do you want to provide some comments?
yeah, Madam Chairman, I think with the, whatever the First Amendment was, where we go back to mental illness, I think that addresses the staff comment.
Okay, great. Hopefully the whole bill works. Never know. Oh, we're gonna skip that. We're gonna skip 54.
Well, yeah.
Mr. Fuller?
And Madam Chairman, maybe for the sake of efficiency, there was discussion yesterday and then at the previous meeting regarding leaving the costs as they are. And
Yes.
to that end, Senator Kolb had requested an amendment be prepared to do just that. That was handed out yesterday. That would basically leave the costs as they exist in current statute. Versus, going through the next pages, which do contain changes from the current structure. So that may be, just for efficiency, the committee, certainly I have no opinion on the amendment or what the committee does, but just wanted to point that out, that was discussed at the last meeting and requested.
Mr. Fuller, thank you. Very helpful. Senator Kolb, do you have an amendment? And is that amendment still applicable in light of the significant changes we've made? Will it work still?
Yeah. Madam Chairman, I believe it would. The only changes that are made in this amendment, it is lengthy, but the changes are just to nomenclature. So references to emergency detention are changed to emergency custody. Statutory references are changed. But the actual language regarding the costs, none of that is changed in this amendment.
Senator Kolb, are you wishing to move that prepared amendment that you have for us now?
I do wish to move it, Madam Co-Chair.
Is there a second? Seconded by Senator Cooper. Any discussion? Certainly this would be consistent with the purpose of our interim work of even touching Title 25, and of course the strong wishes of your co-chairs to not go down the pathway of trying to change costs for what our work is here in the Joint Judiciary Committee. So question on Senator Kolb's well-crafted and planned amendment to deal with this issue. All those in favor say aye.
Aye.
Any opposed? All right, that motion has passed. Page 56. Having just passed 536. All right.
And then, Madam Chairman, I think with the adoption of that amendment, the next staff comment would be the one on page 60.
Wonderful. And that includes as well, Senator Kolb's amendment also addressed on page 57, line 18, correct?
Madam Chairman, that's correct. That's no longer part of the bill.
All right, thank you. All right, and page 60.
And here, Madam Chairman, I think with the change, there's two pieces. The first is, this is kind of a substantive change to ordinary medical care for purposes of the Child Protection Act. And then the second part of that, though, I think has been resolved with the amendment that gets rid of serious mental illness.
Discussion on this staff comment, particularly lines 12 through 15 on page 60. Does anyone understand what it says? Read it a few more times, let it process in. Representative Yin?
Madam Chair, since this is a change to Title 14, I guess I'd like to know how ordinary medical care is used in Title 14, since that's the definition being changed.
Director Schmidt?
Madam Chairwoman, Representative Yin, I was ordering pizza. What was the question?
Madam Chair, Ms. Schmidt, Director Schmidt, on page 60 of the bill, we change a definition in Title 14 of ordinary medical care. And I wanted to know how ordinary medical care is used to determine whether or not it's relevant to have emergency mental illness treatment in there.
Director, if you can.
Thank you, Madam Chairwoman. Representative Yin, we provide emergency care. We also provide, we've always interpreted this to be mental health care. So if we have a youth that is, for example, suicidal, that's part of what we do. We'll respond to that. We'll get them admitted and treat them. So I don't know if this is maybe just in case, but in practice, we already take care of this.
Further questions, Representative Yin?
Madam Chair, no further questions. I'll make a motion. I'll move to just strike this section. Where's this lines? On page 59, starting with line 21, on to page 60, down to line 6, and remove it from the bill.
Is there a second? Seconded by Crago. Further discussion? Seeing none? All those in favor say aye.
Aye.
Any opposed?
No.
All right, that motion has passed. Okay.
And then, Madam Chairman, I believe with the amendment of the adoption of the Kolb amendment, the staff comment on 61 and 62 goes away.
And we have one on page 64 then. Yeah. So the effective date? Committee members, thoughts? So, I mean, 108 it would be January of 23, would be 180 days from when the Representative Washit?
I just wondered if the interim director might comment about their capacity to crank out the rules.
Madam Chairman, excuse me, Representative Washit, this morning when I shared the comments with the committee, there were provisions contained in the bill that have now been amended out. I think our capacity to do the rule promulgation would be easier within 180 days of the effective date. But I will just mention to the committee that if this were, for example, to be effective July 1st of next year, I think we would struggle to hit that. I think we could do it. But some of the policy considerations in here, I think, warrant a little bit more stakeholder engagement. For example, if the department, as the bill is now written and amended now, were to promulgate all of the Title 25 transportation standards through rule, we would want to have significant conversations with law enforcement agencies around the state. That's a big issue. So selfishly, I think we would appreciate a delaying of the effective date to allow some more time to do that. But certainly don't want to sit here and say that we can't hit a rule promulgation date. We would. The quality of that engagement might suffer.
Go ahead, Representative Washit.
I would move that the effective date be extended by that 180 days. That'd be 180 days following the effective date that the rules would be complete. I don't know how to phrase that exactly, but give them a full 3 months beyond the passage. So normally, I guess we would make this effective July 1, that we'd make it effective 90 or 180 days later, 6 months later.
Representative Zwanitzer.
I guess just question, so this goes into practice, does it need to coincide with the state fiscal year? I mean, we could put it in January, but if you have existing contracts, or I'm trying to think what all we've done for the past 4 hours with counties and budgeting, if it doesn't make sense just to delay it a year, make sure everything's fine tuned and it becomes effective in like June of 2023.
Madam Chairman, Representative Zwanitzer, I'm trying to think of all the things that were done today too. It's not without precedent to have a bill take effect that requires rules, but have it take effect on January 1st but I'd have to think about whether or not we would have any contractual issues. I don't think so, but 180-day delay or 360-day delay, I think would be appreciated by the department for the rulemaking provision.
I do think that this is an amendment that can be made potentially at our next meeting or even in session again, because it's a pretty easy amendment and one that we'll have our arms around a little more.
I withdraw my amendment.
All right. All right. Thank you, Representative Washit. Great job, committee. Great job. I think we've worked very hard through all of these staff comments. I think additional direction to LSO and to members of the public and to the committee. I think the co-chairman and I did discuss, and I think we're going to move forward with asking for another half-day meeting that would be entirely by Zoom to allow us additional opportunity to hear from stakeholders and to see the next amended version of this bill draft and have us work it at that time. It's possible that we would be able to get a time frame in December. And so that's what we're going to look to first. Again, it would be a half-a-day meeting entirely on Zoom. So there's no need to make a motion or do a roll call vote on this bill at this time. It's certainly not ready for the committee's adoption. I do think it is helpful on our next bill draft for LSO with the staff comments. Since we have gone through all those staff comments, I don't think we were very clear on which of those items we think need to remain for our review later and which we have disposed of. So I apologize for that. Do your best.
And Madam Chairman, I think in that regard, I took, if the committee discussed it and was silent on it, and we moved on, that those would be the staff comments that I would remove from the next draft.
Wonderful. I think that will be helpful for the committee's consideration. And then, of course, we look forward to having new staff comments for our review as well. For all of the stakeholders that have hung in there today on a very painful afternoon with us on a huge bill, thank you so much. I think you've been instrumental in our work here. What I would say is, and to the county attorneys as well, how you provided the information to us, both from the Department of Health and the county attorneys, was very, very helpful. So for our next meeting, if we could get those comments either emailed to the committee, in advance, so we can get those printed out and by our sides on our home computers while we're Zooming, that will be very effective and allow us to do good work. With that, committee, any further comments on this bill? Representative Washit?
Thank you, Madam Chair. I'd just like to extend a thank you to you for your flexibility and allowing us to work this bill in a very uncustomary fashion. I think it worked much, much, much better than if we just stuck to the process and said, you know, public comments closed, we're going to do this ourselves. So thank you very much for that flexibility.
All right, well, thank you for that. All right, with no further comments on this bill, we'll let you know as soon as we have a date. Yes, Representative Provenza?
Thank you. I just wanted to ask if there's any possibility that we could maybe invite some maybe disability advocates or organizations within the state of Wyoming that would present information from the patient's point of view. If that makes sense. So I think Wyoming has the patient protection and advocacy group. And I don't know if they need a formal invite or not.
Yes, Representative Provenza, if you want to provide information to me and Co-Chairman Olson about who you'd like to invite, that'd be great. And then, of course, the Department of Health and Department of Family Services and WAMSAC, you probably know better than we do who maybe some of those folks might be. You know, obviously feel free to invite them as well. So with that committee, we're not quite done yet, but feel free to start packing up. You're not being rude, but we will go through our summation of the committee's work of the last 2 days. So we have a reminder of what we have done. So Mr. Fuller, thank you. If you're prepared.
Madam Chairman, the committee, here's what the committee did. The committee voted to sponsor 22 LSO 175 pre-application determinations, 22 LSO 111 juvenile justice data system, 22 LSO 238, the bill draft for district judges and authorization and funding, 22 LSO 266, judges housing allowance, 22 LSO 118, contracts and restraint of trade, 22 LSO 121, the dissolution of county boards bill draft, 22 LSO 190, the bill draft that amended liability for governmental health care providers, 22 LSO 186, which was the amendment to the Sex Offender Registry Act. The committee failed to sponsor 22 LSO 176, the juvenile delinquency placement bill draft, and then 22 LSO 187, the parentage amendment bill draft. The committee took no action on 22 LSO 181, which was the Title 25 bill, the duplicate for the state costs, or 22 LSO 183, which was just amending the cost provision of current law. And then 22 LSO 178, which was contracts and restraint of trade 2. That was the Colorado version. Madam Chairman, under your and Chairman Olson's direction, I will draft a letter to Management Council. And then the only other kind of action item is a report from the Division of Criminal Investigation to the committee early next interim with an update on the crime data reporting.
Mr. Fuller, excellent. Remarkable. How about a round of applause for our LSO staff? Thank you so much, committee. I think we've had a very, very, very productive interim. I have appreciated all the work that we have done together in coming here today. This is what the Judiciary Committee looks like when we're working hard and working through these bills, and I think doing great work for the people of Wyoming. Safe travels home. Have an excellent weekend. Look forward to seeing you on Zoom.